return to something Justice Sotomayor asked under this statute, okay? So now we're in the statute. It's a major question, though. Could the president impose a 50% tariff on gas-powered cars and auto parts to deal with the unusual and extraordinary threat from abroad of climate change?
It's very likely that that could be done. Very likely.
I think that has to be the logic of your view.
Yeah, in other words, obviously this administration would say that's a hoax, it's not a real crisis, but...
I'm sure you would.
Yes, but that would be a question for Congress under our interpretation, not for the courts.
All right. And then on this inherent authority idea, I understand the president's inherent authority in wartime, and a lot of your examples of regulating commerce, and maybe your best one, Hamilton, during the Civil War, they occurred during wartime when the president's commander-in-chief power is clearly in play. Does the president have inherent authority over tariffs in peacetime?
No, we do not contend that.
Okay.
And in fact, I cite, if I may, I point the court to two cases. They're Loving against United States and then Masery that's cited in Loving. Those are situations, for example, Loving against United States, the president had broad Article II inherent authority. There was the commander-in-chief power. But this court held he does not have inherent authority to do the power that was delegated to him, right, which is the power to, identify aggravators that make you eligible for the death penalty in court-martial trials. And yet this court said, well, we're not going to see a delegation problem here, even though it's really a wholesale delegation, which would otherwise be legislative authority. It would be kind of like a small version of what you're hypothetical. It would be an abdication. But because you're in a foreign affairs context or their commander-in-chief military context, where the president has his own delegation of authority, he doesn't have the power to do this, but because of his background inherent authority, the court said this is a situation where we're not going to see a delegation problem when there clearly would have been a delegation problem in the domestic context. And those cases, I think, are powerful here.
General, if I can cut through those words, I think you're saying that no, the president doesn't have inherent authority over tariffs in peacetime.
Absolutely. That is, we do not assert that. We say that Congress can delegate that to him, and when Congress does so, as it does when it uses the phrase regulate importation.
I follow all of that.
I agree.
Okay. You emphasize that Congress can always take back its powers. You mentioned that a couple of times. But don't we have a serious retrieval problem here? Because once Congress delegates by a bare majority, and the president signs it, and of course every president will sign a law that gives him more authority, Congress can't take that back without a supermajority. And even then, it's going to be veto-proof. What president's ever going to give that power back? Pretty rare president. So how should that inform our view of delegations and major questions?
I would look at the balance that Congress struck, because what Congress did initially, it had a two-house legislative veto.
And we struck that down.
Yeah. And then Congress went back to the statute and amended it. Yeah. It took out the legislative veto and left in the joint resolution, but still left the president with all those powers.
That's what Congress did?
Yes.
Fair enough. As a practical matter, in the real world, it can never get that power back.
I disagree, because in January 2023, Congress voted to terminate one of the biggest IEPA emergencies ever, the COVID emergency, and the president went along with that. So what the statute reflects is there's going to be the ability for a sort of political consensus against a declared emergency.
Well, what happens when the president simply vetoes legislation to try to take these powers back?
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, so Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight
with the president's assent.
Meaningful.
With the president's assent, in fact,
once he lost it by a veto-proof majority in the Senate, I think the position moved. And I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority to get it back. Yeah. Okay. One other question. Do you think tariffs are always foreign affairs?
I do think they would. I can't think of a situation where they're not foreign facing. If you're talking about tariffs on imports, I mean, Maybe there are other tariff contexts that I'm not aware of, but yes, they typically would involve a foreign affairs thing. However, as in Gibbons against Ogden, if they are revenue-raising tariffs, they would not raise the same sort of like foreign affairs issues as regulatory tariffs, which are imposed not for the purpose of raising revenue, but to induce foreign powers to change their behaviors.
So revenue-raising tariffs are not foreign affairs, but regulatory tariffs are.
I don't think a revenue-raising tariff would be foreign affairs to the same degree, at least. I think it has a foreign application, obviously, but I don't think it would raise the same issues.
Okay, thank you, General.
Justice Kavanaugh?
Figuring out what regulate importation means is obviously central here, and for major question purposes, I think the way we think about that kind of question is, does the specific authority, power, major power, now asserted pursuant to that general statutory authorization, was that the kind of power that would have been understood by people, by Congress at the time the general statute was passed, as distinct from being a novel kind of use of that general authority to do something different? Unheralded is the word in our cases. Okay. One problem you have is that presidents since IEPA have not done this. Your primary answer, or one of your many answers to that, is the Nixon example. And that's a good example for you, because Nixon relied on regulate importation to impose a worldwide tariff. Good example. What is our understanding of Congress in 1977 vis-a-vis that Nixon example when Congress reenacts or enacts the regulate importation language into IEPA?
Congress at that time was fully aware that a Court of Appeals with exclusive jurisdiction had interpreted that very phrase very visibly, very prominently to include the power to tariff, and then reenacted it without change. The court addressed a kind of lesser situation in Algonquin when it came to Section 122, and the court said President Nixon interpreted this to include a tariffing power, a tariffing-like power, and then Congress a few months later reenacted the language without change, and that's powerful evidence of congressional acquiescence. So that immediately historical background is very powerful, and it's buttressed, of course, by sources going back to the founding, where we say the phrase regulate importation, a quintessential application of that is the power to tariff. That's how you regulate.
Why, this may require some speculation on your part, economic philosophy, et cetera, but I'll ask it. Why do you think Presidents Clinton, Bush, Obama have not used IEPA to impose tariffs on, because there have been trade disputes, and certainly, you know, President Bush, steel imports and the like. Why do you think IEPA has not been used?
If you look at those 69 emergencies, in fact, you go through them one at a time, which we had our team do, it's really hard to find one where you look at that emergency and you say, oh, tariffs is the natural tool you would use to address that emergency. So, for example, the Blood Diamond emergency, you know, tariffing these sort of, you know, criminal organizations in Africa that are financing terrorism to the sale of diamonds, you don't really tariff them. Or you take, you know, the Iranian hostage crisis. President Carter didn't say, oh, you seized all of our, you know, embassy personnel, you're holding them hostage, we're going to tariff you, right? And if you go through those emergencies, there are two emergencies, though, where tariffs are the obvious natural tool for a president to use. One is the Nixon balance of payments deficit problem, and the other is this particular emergency. And also there's political reasons. I think that it's no question that President Trump is by far the most comfortable with the tariffs as a tool, both of, you know, economic and foreign policy, than many of the others presidents may have been. I mean, there are presidents like President Bush who, you know, probably wouldn't have naturally, you know, selected that particular tool or method. But if you go through all 69 of those intervening emergencies, what they have not done, at least, is they have not identified where they say, oh, here's one where tariffs would have been the obvious tool, but the president didn't use it.
Algonquin, as you've mentioned many times, is obviously very important here for us to understand exactly what's going on in Algonquin. The phrase there is different, adjust imports, and they really, the other side, your friend on the other side, really relies on the difference in language. And I just want you to give your best answer to why regulate importation encompasses tariffs when adjust, we held that adjust imports would encompass monetary exactions.
Three answers, if I may. Adjust is narrower than regulate. And so, therefore, the greater includes the less.
Follows.
Second answer, Adjust is the second Black's Law Dictionary definition of regulate. The Black's Law Dictionary, our original plain meaning dictionary definition, says adjust by rule, mode, or rule, method, or established mode. So there's just a plain meaning link there. Regulate, adjust is a form of, is a kind of regulation. And then I think far more importantly, regulate importation, I can't emphasize enough, going back to the time of the founding has been understood that the manner in which you regulate importation, the natural way to do that is to tariff. So it'd be textually astonishing, given that historical pedigree, going back to Gibbons, going back to, Madison's letter to Cabell and all the historical sources cited in our briefs, it'd be kind of astonishing to say, hey, President, you can regulate imports, but we're not saying this explicitly, but you do not have the power to tariff, when the tariffing is in many ways, the quintessential way of regulating importation. So that historical pedigree, sort of gives freighted meaning to that two-word phrase.
And last, you had some discussion about license fee versus tariffs, if there's a distinction. I mean, the counsel in the oral argument in Algonquin said they're all monies exacted on imports, so in that sense, it certainly is a tariff, and hence all the incidents and the economic effect of a tariff. But we can't rely on what the counsel said in Algonquin. Isn't there a difference of sorts, at least, between a tariff and a license fee? You answered this, I think, briefly before, but I want to make sure, because I think this could be an important point, because I want to know Algonquin to decide this case. So give your best shot on that.
I agree that there is, maybe there's a formal distinction. But as a practical matter, I think what counsel was probably arguing there is that there really isn't much of an important distinction. And I would point to the passage in Algonquin where the court says, look, they've conceded that this includes the power to quota, and since quotas are a quantitative method, it would make no sense for Congress not to grant the qualitative method, and all the more so here if there's a concession, as they do in some of the red briefs.
One time the court said monetary methods, i.e. license fees, and the next page said monetary exactions, i.e. license fees and duties.
I think the court bought the argument. It's
important to be consistent.
That there's really not a lot of daylight between those two. As a practical matter, certainly almost no daylight. And so then the question...
When you say almost no daylight, just...
I would say that they're economic equivalents. Legally, they're pretty much the same. So I really don't see a big distinction there. And of course, the logic of Algonquin was, quantitative methods quotas are allowed. Therefore, it would make no sense at all to interpret this not to include the qualitative or the monetary exaction methods. Well, if we're talking about a distinction between regulated importation, including licenses that could come with fees, but not tariffs, that logic applies all the more so.
Thank you.
It makes no sense.
Justice Barrett?
Well, I think in Algonquin, there was a formal distinction that mattered, because at that oral argument, counsel pointed out that the uniformity clause would kick in, and the constitutional uniformity requirement would apply to tariffs if it was that way, and speculated that the reason that the government may have set it up as a licensing scheme with licensing fees was to avoid that. So I do think there are some distinctions, but keeping that in mind, if you say that there really is, as a practical matter, no difference, this is kind of what I'm hung up on license, that maybe you can help. So in IEPA, Justice Sotomayor is right, license is used as a noun, but it's one of the means necessary. So in Algonquin, it was by any means necessary adjust. Here the statute says the president may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, regulate importation, which is the key part for our purposes. So the means it specifies are instructions, licenses, or otherwise. So I think it would, one argument might be that it would have been natural for Congress to put the president may, by means of instructions, licenses, tariffs, or otherwise. With an adjustum generis thing, I think you have to rely on the or otherwise, picking up more. Or if there really is no practical difference between licenses and tariffs, why aren't you making the argument, or why didn't the president structure this as a licensing fee scheme? How do I understand that language? Or am I just misunderstanding it and this language is totally irrelevant?
I think that, here's the way I'd respond to that. I think that language powerfully reinforces our position as the way you've laid it out right there. Because, first of all, regulated importation we say, and based on extensive historical pedigree, the core application of that is tariffing. To list tariffing again would have been essentially redundant and unnecessary, especially if you look at the specific historical background of TWIA, where TWIA was enacting a tariffing power or a licensing-like power, that was described as, again, duties and tariffs equivalently.
Okay, but I don't understand, because I think you have to put together A1 and then B. So I think what you would be saying is he may prescribe by means of tariffs.
I think what you're saying is by means of instruments, licenses, or otherwise.
By instructions, licenses, or otherwise.
Instructions, licenses,
tariffs?
otherwise.
Okay.
That otherwise, I mean, if you say instructions, license, or otherwise, and we're asserting a power that's very, very similar to licensing, otherwise naturally carries that with it. But that's not our principal position. Our principal position is regular importation means that.
Okay.
Right? And so you don't need to say it again. However, if Congress has authorized them to do it by licenses that could come with fees that are economically equivalent to tariffs, and then it says otherwise, that just reinforces the same conclusion that we get by using the phrase.
Okay, then question just to follow up on Justice Gorsuch's thing about how can Congress ever get this delegation back. You said, well, listen, you point to the Congress's ability to terminate emergencies, which it's done. But if Congress ever wanted to get the tariffing power back, it would have to have a veto-proof majority, because regardless of the emergency, so if Congress wanted to reject let's say that we adopt your interpretation of the statute. If Congress said, whoa, we don't like that, that gives a president too much authority under IEEPA, it's going to have a very hard time pulling the tariff power out of IEEPA, correct?
I don't know if it'd be a hard time. Certainly would have to have a statutory amendment, which would be true of any case where this court definitively interprets a statute. Yes, I think that the
But definitively interpreting a
statute
statute that grants presidential power makes it particularly hard to get the president to not want to veto something, which, as Justice Gorsuch is pointing out, has him lose power. All right, I want to ask you a question about unusual and extraordinary threat, which we have not talked about yet. And I specifically want to talk about the reciprocal tariffs. These are imposed on, these are kind of across the board. And so is it your contention that every country needed to be tariffed because of threats to the defense and industrial base? Spain, France, I could see it with some countries, but explain to me why as many countries needed to be subject to the reciprocal tariff policy as are.
Yeah, Executive Order 14257 spells out the nature of the emergency and basically says that there's this sort of lack of reciprocity, this asymmetric treatment of our trade with respect to foreign countries' trade that does run across the board. It is a global problem. I think that puts in context the argument they make that this power to tariff is so broad because you're applying to every country in the world. That conflates the nature of the tool, tariffing, which they're challenging here, with the nature of the declared emergency, which they haven't disputed. They haven't disputed, for example, that the president has correctly identified that virtually every major trading partner has this longstanding sort of asymmetric, unfair treatment of our trade. So the argument this power is so broad is really based on a conflation of two different things. One is the power, right? Imagine this. Imagine that, for example, President Reagan had wanted to convince South Africa to change its apartheid policies, and he'd impose tariffs on them. No one would bat an eyelash and say, well, that's too broad, that can't be an IEPA. The power to tariff is fits naturally with all those powers to block, prohibit, and seize and so forth. What they're saying, this is so broad because the emergency is so broad. But of course, that's a presidential determination and there's all kinds of basis for it. And also, keep in mind that the emergency is not like just the asymmetric treatment, it's the impact of the asymmetric, the underlying conditions, the hollowing out of our manufacturing base, the vulnerability of our supply chains, and of course, our defense industrial basis, vulnerability of key inputs.
Justice Jackson?
So as I understand your response to Justice Barrett in that last question, you're saying that the power to tariff fits naturally with the power to block and seize. That was your example. But I guess I'm trying to understand then your argument from the text of the actual statute. Because the statute, unlike what you suggested to Justice Kagan, is focused on the actual actions that the president can take. In response to Justice Kagan, I understood you to say that Congress was giving the president broad authority to act, and it was within a particular domain, which is the domain of emergencies with respect to foreign power, but the president could basically do a lot of things. But when I read the statute, it is telling the president exactly what he can do: investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit. And I guess what is a little concerning to me is that your argument suggests that we should see the word imposed, the phrase imposed tariffs, in that same series of things that the president could do. We don't see that word, and instead you take regulate and say that must mean that. So I guess I'm getting back to Justice Barrett's maybe original question, which was, where else in the code has Congress used the word regulate to sub in for imposed tariffs?
TWIA, and then this court's opinions, of course, have used regulate and import, or have pointed out that duties are the natural way to regulate foreign commerce.
But you're saying we should not have expected to see the same level of granularity with respect to the president's authority to impose tariffs as we see here: investigate, block, direct and compel, nullify, et cetera.
I think it would be very unusual for Congress to spell out all the ways that you can regulate in that statute.
So regulate becomes a big catch-all. The rest of the other things.
Well, I mean, we have a concession of that from the other side, that regulate at least includes qualitative methods, quantitative methods, quotas, licenses. They've conceived that regulate, there's a lot in regulate that's not spelled out there. And our point is, you don't need to spell out tariffs, because that's, like, of all of them, the most natural, the most quintessential method of regulating imports.
And yet, many presidents have not used regulate in this way to impose tariffs. I understand you point to President Nixon. We have licenses from Lincoln, but no one else.
Justice Kavanaugh, presidents who are faced with international crises to which tariffing is the natural response, that's President Nixon and President Trump, have invoked this authority. And also, frankly, President Trump invoked this authority in May of 2019 as well.
Can I ask you one question?
It's more historically attested than they can see.
Let me just ask one more question about the unusual threat. So in your conversation with Justice Gorsuch, we had the climate change tariff hypo, and you indicated that there would be challengers to the notion that that was an unusual and extraordinary threat. And I'm just wondering, under your position, would they be able to make a legal challenge? Are you saying the court would not be able to review?
On that particular hypothetical, I think I said that'd be a question for Congress.
So not
Yeah, I don't. In other words, that wouldn't be the sort of thing that courts would want to wade into. Is this really an emergency? That would not be probably very unlikely. That'd be a situation where at least there'd be very, very, very deferential judicial review of that kind of determination.
No, I'm asking you.
Dispute,
right, those are two different things. Is there no judicial review, or is there deferential?
Our frontline, I mean, Trump against Hawaii. Our frontline position is that it falls within Dalton against Specter. It's committed to the president's discretion when he makes his determination of a national emergency. But the court doesn't have to decide that because whatever review is very, very deferential. It's easily satisfied here.
Thank you.
Thank you, counsel. Mr. Katyal.
Thank you, Mr. Chief Justice, and may it please the court. Tariffs are taxes. They take dollars from Americans' pockets and deposit them in the U.S. Treasury. Our founders gave that taxing power to Congress alone. Yet here, the president bypassed Congress and imposed one of the largest tax increases in our lifetimes. Many doctrines explain why this is illegal, like the presumption that Congress speaks clearly when it imposes taxes and duties, and the major questions doctrine. But it comes down to common sense. It's simply implausible that in enacting IEPA, Congress handed the president the power to overhaul the entire tariff system and the American economy in the process, allowing him to set and reset tariffs on any and every product from any and every country at any and all times. And as Justices Gorsuch and Barrett just said, this is a one-way ratchet. We will never get this power back if the government wins this case. What president wouldn't veto legislation to rein this power in and pull out the tariff power? IEPA is a sanction statute. It's not a tax statute where Congress gave away the store. Congress knows exactly how to delegate its tariff powers every time for 238 years. It's done so explicitly, always with real limits. IEPA looks nothing like those laws. It uses regulate, which Congress has used hundreds of times, never once to include tariffs, and it lacks the limits of every other tariff statute. And that is why, even though presidents have used IEPA to impose economic sanctions thousands of times, no president in IEPA's 50-year lifetime has ever tried to impose tariffs. And the president bypassed statutes that do address tariffs, like Section 122 for large and serious trade deficits, but that imposes a clear guardrail, 15% cap, 150-day limit. This is Youngstown at its lowest ebb. If the government wins, another president could declare a climate emergency and impose huge tariffs without fines or without floors or ceilings, as Justice Gorsuch said. My friend's answer, this administration would declare it a hoax. The next president may not quite say that. This is an open-ended power to junk the tariff laws and is certainly not conveyed by the word regulate. I welcome the court's questions.
Wouldn't your argument also apply to embargoes?
So, and this is the argument in the fine dissent below, and I think there are three answers to that, Justice Thomas. The first is revenue raising. Embargoes stop the shipment. Tariffs start the tax bill. They are first and foremost ways of regulating revenue. As some of your own opinions said, this is the way we actually chiefly got revenue for the first 100 years of our republic. Tariffs are constitutionally special because our founders feared revenue raising, unlike embargoes. You know, there was no Boston Embargo Party, but there was certainly a Boston Tea Party. The second thing, textually, in the statute, it's different. Regulate appears in a cluster of verbs, as was said before, investigate, block, nullify, and the like. They describe embargo-like controls, prevent and prohibit, for example. But they don't describe revenue exactions. That's Justice Kagan's point. The one verb that's missing here is anything about raising revenue whatsoever. Another point, congressional displacement. Today, there is a whole host of statutes in the tariff architecture of Title 19, which both expressly confer the power to tariff and always impose clear limits. Embargoes by the president, embargoes don't have any of that. They don't set aside that whole thing. If you look at the Learning Resources brief at page 5, it goes through these statutes in detail. Section 122 expressly says duties and then limits it, 15%, 150 days. Section 201, any duty on the imported article, but it requires ITC findings. Section 301, impose duties. That's the language of the statute, but all sorts of procedural restrictions. Section 338, the same. I can go through this, and I could start, by the way, Justice Thomas, with the statutes at the founding, all of which expressly said the word tariff or an equivalent.
Let's go back to your non-delegation point. It would seem that if the tariff power cannot be delegated, your argument on non-delegation would also have to apply to embargoes and to quotas.
No, Your Honor, because I think tariffs, because they're uniquely revenue raising, impose special, unique concerns that go back to our founding. And so I don't think that they apply to embargoes. And indeed, the history of this is very, very clear. That, as you just heard my friend say, in 1790, George Washington was delegated massive embargo power from the Congress. But what did Congress not do? And this is why the example cuts the other way. They never gave the president any sort of delegation of tariff authority at the time. Our point is not you can't delegate tariff authority. It's simply that you've got to do so with intelligible principles. And what you just heard my friend say is every single limit in IEPA is one that is not judicially enforceable. There's no limit whatsoever. And indeed, the main limit that was in there, he calls this some compromise position. The only compromise in 1977 was the legislative veto. And as this case comes to the court, that's no longer in the statute at all.
Counsel, yes, sure, the tariffs are a tax, and that's a core power of Congress. But they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry.
Oh, sorry. I'm sorry.
Were quite effective in achieving particular objectives. So I don't think you can just separate it when you say, well, this is a tax to Congress's power. It implicates very directly the president's foreign affairs power.
Yeah. Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime.
Well, you don't agree with a large part. What's the little part that you do disagree?
So we agree with the idea that tariffs have foreign policy implications. Absolutely. Absolutely. Our founders recognize that. That's in the Federalist Papers. But nonetheless, they exclusively committed that power to the Congress in Article 1, Section 8, and gave it as its first power. So when you hear my friends cite cases like Egan and Garamendi, they just don't apply to this specific, unique situation in which Congress has given that power. And if you were tempted by this, I think the best place to look is Youngstown, because what Justice Jackson said, and I was surprised that he quoted pages 652, because what Justice Jackson said is, quote, emergency powers tend to kindle emergencies, so it's essential the public may know the extent and limitations of the powers that can be asserted, and persons affected may be informed from the statute of its rights and duties. And Justice Jackson went on to say there that it's notable our founders didn't give the president revenue-raising power even in a time of war.
Can I just get a clarification of your answer, which is you agree if the word tariff were in the statute, that would be acceptable and constitutionally permissible, correct?
No, it'd be constitutionally permissible. The question would then be, is the open-ended assertion of power here, because every other tariff
I
statute
get as
has
applied to this
limitations.
case, but the general point is, yes, Congress, you said it's assigned to Congress, but Congress can grant authority to presidents to impose tariffs.
Absolutely.
As a general proposition.
Absolutely.
Okay, so we have to figure out then what regulate importation means. And you've heard my questions. If this statute came out of nowhere in 1977, I think your case would be, obviously stronger. We have to figure out, at least I want to figure out what the Nixon precedent stands for and what Algonquin stands for. On the Nixon precedent, the question is, I think, was Congress aware of that, meaning that when they used regulated importation and it's now being used to encompass tariffs, that's not unheralded because Congress was well aware. President Nixon announced those tariffs in a nationwide primetime speech, 10% across the board in August 1971. It was not some kind of little piece of paper. So it was well known. The question then is, was Congress, why didn't they change the language? Why didn't they say regulate but not tariffs? That's kind of the difficult question from the Nixon precedent that I'll give you an opportunity to answer.
Thank you, Justice Kavanaugh. So 5 answers on the Nixon precedent. First, there is no evidence that Congress thought it was ratifying Yoshida. It was a single Court of Appeals case.
It's not somewhat my question. I never mentioned Yoshida. It's the use by the president of that power under regulated importation.
Oh, if we're just talking about that, President Nixon did not rely on the statute whatsoever. I mean, that's very clear. In fact, we have a Marshall McLuhan moment here because you have before you Alan Wolf, the person who was there in the room with Nixon, saying Nixon totally disagreed that the statute applied. So if we're just talking about Nixon, I don't think it can get the government where it
Go to your
wants
other
to go.
four.
Yeah. So I think the only way it does any work is if the president is through the vehicle of Yoshida, and that's what I take it the government is arguing. And with respect to that, this cert-denied intermediate court of appeals decision, I don't think it can come close to overcoming the clear, plain text. The word regulate is words regulate importation. The word regulate has never been used. The Congress has used the term 1,499 times. We've got about that number of hits when we looked at it. And maybe there's some double counting, but it is never used even once to impose taxes or revenue raising. And that was the question that Justice Barrett was asking. And so I don't think that this intermediate court of appeals decision will get you there. And then even if you thought that Congress knew about Yoshida, and even if you thought they liked it, which there's absolutely zero evidence of, I don't think that helps the government for reasons that Justice Alito was pointing to, because Yoshida said 3 things. A, TWIA doesn't give the unlimited authority that the government is seeking here. B, they were only upholding the limited specific assertion of authority that President Nixon sought there. And third, going forward, the solution, they said in footnote 33, was to use Section 122 of the 1974 Trade Act, 15%, 150 days. And we have no problem with the president doing that. It's just that this president has torn up the entire tariff architecture. For example, he's tariffing Switzerland, one of our allies, which we have a trade surplus, 39%. That is just not something that any president has ever had the power to do in our history. And the idea that Congress, by implication, did this in 1977 and handed him all this power, I think is really difficult.
Just ask the other, go ahead.
Let's start with just the bare statutory language. You have arguments about structure, you have arguments about history. There are strong arguments, but let's just start with the bare statutory language, regulate importation. If we disregard all of the rest, would you dispute that that would include the imposition of a fee?
So if it's revenue, yeah, we do dispute that, absolutely.
What if there were a statute that said, I mean, suppose that there's a particular national park that's very crowded, and Congress passes a statute that says the National Park Service may regulate admission to the park. Would you say, well, that does not allow them to impose a fee?
So, Your Honor, sometimes we think of fees as not revenue raising, but rather capturing the cost of government services. In your example, the going to the park, that may, those kinds of cases, which I think.
Suppose it goes beyond the cost of running the park. Congress just wants to control admission to the park, regulate admission. Wouldn't that include the imposition of a fee?
So if it doesn't raise revenue, then, and it's not about that, then I think that's fine. If it does,
it raises revenue. That's
then I think it's a
that's
tougher
the hypothetical. That wouldn't apply.
So I think in that circumstance that it wouldn't be a regulation in context. It wouldn't be permitted. That is, at least in the context of tariffs and trade, we know, Justice Alito.
Okay, well, that gets into your other arguments. We start out with the bare statutory language, and that was what my question was about. Do you think all tariffs are revenue raising? Suppose that instead of imposing these across the board tariffs, suppose that an executive order imposed a tariff on one particular country and provided that this would take effect in 90 days. And suppose that within those 90 days, an agreement is reached with that country so that no tariff is ever collected. Would that be a revenue-raising tariff?
I take it the initial point and on its face, it is revenue raising, that's what it's for. And so I think that would. And look, I don't doubt that there are edge cases. That is what this court's confronted just recently in FCC versus Consumer Research. And you said, look, what is a tax? It's sometimes very hard. What is revenue raising? This is obviously revenue raising. Their own brief to the court says it's going to raise $4 trillion. And Justice Alito, you in your Consumers Research dissent, or Justice Gorsuch's dissent that you joined, said taxation is special and different. And it is the most powerful thing the government does. And the idea that Congress, when they know exactly how to write tariff and tax statutes, gave this power by implication through the word regulate, I think is very, very hard.
Well, you cite many different statutory provisions that impose tariffs. And you have a point if that's the relevant universe. What if the relevant universe is tariffs that are imposed in emergency situations?
Yes, so I think it cuts the other way. So, as Justice Jackson said, it's when you're in an emergency situation, the statutes actually have to speak with more precision. The public needs to know because emergencies beget emergencies. And I would say the best way of understanding what Congress does in emergencies is to look at their emergency statutes. Not one has ever given the president a taxation power or a tariff power. We've had all sorts of emergencies for 238 years. No president has ever said, oh, the way to deal with that is I need to have a tariff authority. And as Justice Sotomayor said, IEPA gives already a quota power, so you can get what the foreign policy piece of it is through that. I'd also say, Justice Alito, Dames and Moore, which the Chief Justice referred to earlier, I think is really important here because the Solicitor General in that case made a similar argument to what you just heard on the claims provisions. He said it falls within regulate. Regulate is a capacious term. He said, Justice Alito, what you said, this is an emergency situation. And he said you've got to defer to the president on a major issue of national security about this very statute. And what did the court do? It rejected those arguments and said IEPA doesn't cover this.
You say that this is not, this case does not, these executive orders do not address an unusual and extraordinary threat. I understand that argument. Suppose that the facts were that it was suppose that there was an imminent threat of war, not a declared war, but an imminent threat of war with a very powerful enemy whose economy was heavily dependent on U.S. trade. Could a president under this provision impose a tariff as a way of trying to stave off that war? Or would you say no, the president lacks that power?
Couldn't do tariff, but could do quota, embargo, all of those things.
Could do all those things, but the president could not impose a tariff.
There's
That's
a
the one thing he couldn't do.
There's a category shift between a tariff and the other 8 powers in IEPA because it is revenue raising. So it's not a difference in degree or something like that. That's why, I don't doubt tomorrow.
Even if the purpose of this had nothing whatsoever to do with raising 1 penny. The president didn't want to raise 1 penny. The president wanted to deter aggression that would bring the United States into a war. You would say, no, can't do that.
Yeah, Justice Alito, I think you've said many times the purpose isn't what you look at. You look to actually what the government is doing. And if you disagree, if you think we're, if you think, or excuse me, if you ruled for us and the president says, I need this power, he can go across the street to Congress tomorrow and get it by a simple majority through reconciliation. But if you vote for them, this power, as Justice Gorsuch said, as Justice Barrett said, is going to be stuck with us forever. The power to jump.
Can I ask you?
I just wanted to give you a chance to address kind of the other argument that's been submerged here textually. Again, just bare text for a moment, okay? We've been focused on regulate importation, but actually the statute says the president may, by means of licenses or otherwise, regulate importation. And we've had some discussion today about the fact that maybe the president could simply recharacterize these tariffs as licenses or rejigger the scheme so that they are licenses. We've also heard the suggestion that otherwise, licenses and tariffs are very similar, so otherwise might encompass tariffs there. Thoughts?
Yeah, a few thoughts, Justice Gorsuch. First is the SG is not even making that argument, and I think they're not making it for a number of reasons. One is that there's a strong presumption against reading statutes this way in the unique tax and duties context. Hartramp is one of those cases which says if there's doubt, you don't read the statute to confer such powers. Second, if you were to do that, it's open-ended. It allows, and this was your hypothetical, it allows under the word license them to tariff the world,
Seems like you're putting a major questions thumb or an interpretive lens thumb on the plain text there. Is that fair?
I think you could call it major questions. I just think it's like Justice Barrett said in Nebraska versus Biden, the most natural way of understanding what the statute is about. We're talking about, under the government's reading, a statute that gives the power to the president to junk the entire tariff.
I understand that, but you're not disputing licenses or otherwise means what it says. You're saying that we should interpret that narrowly for particular reasons.
So I think I am disputing it as well. I think the licenses, and this is something Justice Sotomayor was saying, don't expand the power. They are not verbs. And so it is limited to the 9 verbs there.
No, I understand that.
And so regulate, I don't think.
Thank you.
Yeah.
Thank you, counsel. Justice Thomas, anything further?
I'd like to just revisit the point that Justice Alito was making with a similar question. If one of our major trading partners, that's, for example, China, held a U.S. citizen hostage, could the president, short of embargoing or setting quotas, say the most effective way to gain leverage is to impose a tariff for the purpose of leveraging his position to recover our hostage?
No, Your Honor. So tariffs are different because they're revenue raising, and I think it goes to the point I was saying to you in our very first colloquy, which is quotas, embargoes, and stuff are different for a different reason, which is there's a tariff architecture around Title 19, in Title 19, that in tariff would, like in your hypothetical, would supersede. And here the president is seeking the power to set aside all of our trade treaties unilaterally under the word regulate. I just don't think it can bear that weight.
Justice Alito?
You mentioned other tariff provisions that you think would be rendered redundant if we adopted the government's interpretation of IEPA. One that you didn't mention, which is discussed in an amicus brief, is Section 338 of the Tariff Act of 1930. Why doesn't the plain language of that provision, which does speak specifically about duties, provide a basis for all or virtually all of the tariffs that are at issue here?
Yeah, the government's never made that argument, Justice Alito, and I think for very good reason, because it only applies to MFN violations, which are not at issue here. You can only tariff if the president, quote, finds as a fact that a country satisfies two conditions, including that it discriminates against the United States. There are also a host of other reasons why Section 338 may have lapsed, and that's why no president has ever used it. But look,
what is the argument that it's lapsed? It's regrettable. I mean, we put this case on a very expedited schedule, and therefore there are limitations on what and the parties' ability to answer each other's arguments or arguments that are made by amici. The amicus brief says that it hasn't lapsed. There are articles that say it hasn't lapsed. What is your argument? What is the basis for your argument that it lapsed?
So two things, Justice Alito. Sections 252 and 301 have been understood by many to have superseded Section 338. And second, I don't think you have to get into this issue at all. We're not here saying that the government doesn't have a 338 power. That's something that can be decided by other courts at other times. As these folks come to the court, as the government comes to the court today, they're citing one statute and one statute only, IEPA, and we submit to you it doesn't come even close to authorizing these worldwide tariffs.
Well, what if the president tomorrow were to say, I'm reissuing these executive orders and I'm invoking, in addition to other authorities, Section 338 of the Tariff Act,
So
1930.
I think at that point we'd have that case. I mean, I'm not here to say that 338 does or doesn't do one thing. I'm responding to the government's argument, which is the invocation of IEPA and IEPA alone. But perhaps that point, Justice Alito, may
So
get
then,
the court some comfort.
I mean, I understand party presentation and all of that, and not being a court of first view. But in these circumstances, if that were to happen, and it might be a realistic possibility, you think, well, okay, then the government would continue to try to collect these tariffs, and the plaintiffs here would have to go back to the Court of International Trade or the district court and challenge it again, and it would have to progress through those lower courts and come back to us when? A year from now? 6 months from now? While the tariffs continue to be collected and the amount that's at stake mounts into the billions. I mean, what are we at now? 100 billion? We get up to $1 trillion? That's what you're suggesting?
So, Justice Alito, I think a few things. One is I think it's rich for the government to be making this argument about the refunds undermining us because they opposed the preliminary injunction in this case by saying, oh, don't worry, we'll give the refunds later. And they sought to stay in the federal circuit on exactly that ground, which was you don't need to implement the federal circuit's decision because we'll give the refunds later on. And now they're suggesting—
Well, that really wasn't my question, Mr. Katyal. The question was whether it would make more sense for us to address that, if that is a possible justification for these tariffs, for us to address that now and get it over with, rather than having this continue for who knows how long while it goes through the through the procedures in the lower courts.
Justice Alito, I think that is forfeited 9 ways to Sunday. This amicus brief has been filed in every single stage of this case. The government's never embraced that argument. For them to be able to do so now, I think is way, way too late. But I do think if you ruled, as we're suggesting you do, against the government, they can go and try and seek to use other authorities, whether it's 338, Section 122, et cetera. Those are the ways prescribed by the Congress. And as Justice Kavanaugh was saying earlier, every other president has used all this suite of other authorities, 201 for steel, for autos and things like that, 301 for countries like China. This president has come along and said something different, and with all due respect, we don't think IEEPA allows him to do this junking of the worldwide tariff architecture.
And what was the view, what were the views of President Trump's immediate predecessors on the question of imposing tariffs or allowing free trade? What was their policy view on that question?
There's been a variety of different views about that, but you know, the executive order, my friend said, well, prior presidents had no occasion to use the tariff power, which is belied by the very executive order he's defending here, which says that the trade deficits have been large and persistent every single quarter since 1976. And we've had trade wars. President Reagan initiated different ones and the use of different authorities, but never once did a president try and seek IEEPA as the basis to rewrite the entire tariff code.
I found it interesting to hear you make the non-delegation argument, Mr. Katyal. I wonder if you ever thought that your legacy as a constitutional advocate would be the man who revived the non-delegation argument.
Heck yes, Justice Alito. I think Justice Gorsuch nailed it on the head when saying that when you're dealing with a statute that is this open-ended, unlike anything we've ever seen, to give the president this kind of power, yes, this isn't just delegation running riot. This is delegation that's a legislative application.
Wouldn't you agree that statutes that confer on the president real emergency powers are often phrased much more broadly than other statutes? Isn't it the very nature of an emergency? I know you dispute the fact that this is a real emergency, maybe it's not, but isn't it the very nature of an emergency provision that is going to be more open-ended?
So, Justice Alito, we think it actually cuts the other way, as I was saying earlier. That's what Justice Jackson said. And, you already confronted that in Dames and Moore and said it's not that open-ended, even though it's an emergency. And by the way, other emergency statutes have very serious limits. Section 122 is literally about President Nixon's proclamation of an emergency. That's what it's about, and it's limited 15%, 150 days.
And what about the authorization for the use of military force in 2001, which gave the president the power to use all appropriate force? Now, that's pretty open-ended. Would you apply the same non-delegation argument there that you do here?
Of course not, because there you have shared powers between the president in Article 1 and Article 2 powers. That's what I was saying.
Well, it gets into the question of whether it was delegated or not. What was the scope of the delegation?
Absolutely, but there, it's military. There's a whole unique history behind that. But here you're talking about something that is exclusively committed to Congress in Article 1. And there, yes, when you have delegations, I would say, Justice Alito, even when you have delegations in some military cases, in emergency statutes, they have all sorts of limits. So 10 U.S.C. 2808 says that in a declaration of war or a national emergency, the president can, quote, undertake military construction necessary to support emergency use of the armed forces,
Thank you very much.
but it has limits.
Justice Sotomayor?
I'm fascinated that the two instances where presidents have used their war powers to impose a tariff, Lincoln and Nixon, that Congress found it necessary to ratify their actions, and that the court in both those cases, the Intermediate Court of Appeals in Nixon and our own court, included that as part of their reasoning, as justifying the use of war power in that situation. So I'm a little concerned why the fact that this act, a domestic act on emergency that uses a general word like regulate, should take on a war powers meaning when in every other situation, whenever Congress intended domestic taxation, it said tax and regulate.
Oh, Justice Sotomayor, I wish I had an hour to talk about this with you, because this argument by the government advanced in their reply brief is wrong, every which way.
I'm saying that's your sixth way of differentiating your CETA, correct?
So
that was a war powers case.
So it's a war powers case. It's about conquered territory. It has nothing to do whatsoever with domestic tariffs. And absolutely, you're right in saying that the way that court, even in those cases, even at the height of the government's power, war powers, they said Congress had to ratify it. And that's what at page 96.
And that hasn't happened here.
And that has not happened here, not even close.
Well, it might not with Congress closed, but they can't even think about it right now. I'm going to assume, and maybe he can shake his head yes or no, that Justice Kavanaugh will ask you to go to Algonquin, which you didn't answer, and he's shaking his head. So I'll let him do that part, okay?
Excellent. Algonquin, Your Honor, is, under...
No, I'll let him do it.
Oh, sorry.
He can... That was his question, but I want to make sure you get to it.
We'll hear from Justice Kagan first.
I have one specific question, one more general question. The specific question is, does it matter in the way we think about IEPA, what Congress thought it was doing in IEPA, what IEPA in fact did, that at the time Congress thought it had available to it a legislative veto?
I do think it's relevant, at least for delegation purposes, because, as this case comes to the court, the one check that was in there, the so-called compromise, is a legislative veto which now no longer exists. And that's why I said to Justice Alito, this statute now looks unlike any other statute with respect to
I guess I'm wondering whether, though, it cuts against you as well, that Congress thought it had a legislative veto, so it didn't put in a variety of checks that it might have put in had it not thought it had a legislative veto. And, that's just tough luck on Congress now.
Yeah, I don't think so. I mean, Justice Kagan, I think it's a very tough common sense argument to make, because every single delegation of tariff power statute from Congress to the president always has limits, and including, Section 122 passed just right before IEPA had, in the case of the exact problem that this executive order is dealing with, large and serious trade deficits, it said the way to deal with it is 15%, 150 days. The idea that 3 years later they just said, oh no, junk the rule book, I think is very difficult, and no Congress, I think, would rely just on the legislative veto for such a thing of such momentous importance. As you said to my colleague earlier, why would any president look to all of the different tariff statutes in Title 19 if you can just IEPA them all, French Revolution them all?
General Sauer rests a lot on the president's inherent authority. And I want to make sure I understand your answer to the Chief Justice and to Justice Alito as to where you think that authority exists in a way that actually would affect our interpretation of a statute, and where you think it doesn't, and why this falls into the second category, given that, in General Sauer's view, this is obviously what the Chief Justice called foreign-facing.
Yeah, so it may be foreign-facing, but there is still no Article II power whatsoever. There is no citation whatsoever in the government's brief to any notion that the president has Article II tariff authority. Now, look, I will say in wartime, conquered territory, maybe, but this is not a wartime or conquered territory statute. This is, or a use of the statute. They are tariffing the entire world in peacetime, and they are doing it, asserting a power that no president in our history has ever had. Even Justice Kavanaugh's example of Nixon, really far more limited, didn't blow past Congress's limits, as was said in Yoshida. This is a whole different animal, and maybe Congress has that power, as I agree with Justice Gorsuch. I don't think that it does, but boy, they got to say so really clearly. And here, there's nothing like that in the text of IEPA.
Thank you.
Justice Gorsuch?
Well, I don't know if I agree with what you say, but at any rate, back to the plain language, and just stick with me for a moment. The Constitution says that Congress gets to regulate commerce, and everybody understood that that meant and included the power to tariff. Story, Madison, okay? So that's sort of a problem, right? Regulate is a capacious verb. And then you've got the otherwise language as well, which we've sort of discussed. And just on the plain language, forget about the backdrop of major. Do you need major questions to win? I kind of think you might.
No, I don't think so. I mean, if we did, I think we'd win for reasons expressed, but I don't think so at all. So, Justice Gorsuch, our position is not that regulate can never mean tax or tariff.
Okay.
Our brief at page 15 gives you an example. A president may regulate cars coming in to the city, and then if it adds by charging tolls or something like that, absolutely, in context, it does. Here, the context you're referring to, Story and so on, says nothing about this case. That is the constitutional context about Congress's use of power.
But it's part of how we understand language is used, and it's relevant for that purpose. And then when you've got licenses, which are economically the same thing as, would you agree they're basically economically the same thing as tariffs?
Sometimes they can be revenue
Okay, so
raising.
you've got something that's economically identical to a tariff authorized by this statute. Where does that leave you?
So let me,
As a matter of plain
let me
language.
take the question in two parts. One is about the word regulate, and the other is about licensing. With respect to the word regulate, when it's used in the constitutional sense, it's very different than the sense in IEPA that my friend is asserting. When we're asserting IEPA, we're talking about a statute that is granting the president massive powers. And so the relevant context that I think you look at in asking the question, what did Congress mean in 1977? The best context, the most natural context is, what does Congress say every time they grant the president such power? And then there's just the one other point on this. Constitutions are read totally differently. Story and Madison are talking about the constitutional phrase, and as Chief Justice Marshall said in McCulloch, a constitution we're expounding, the prolixity of a legal code is the opposite of the way you read the Constitution.
I do follow that argument, okay?
And
what about otherwise, again? I just really want to make sure I understand. You say that there's a good reason why the Solicitor General didn't make that argument. I'll be curious to see what he has to say about that. But you know, what's your best reasoning why the otherwise language doesn't?
Because it's only a mechanism to implement the 9 powers, and that licenses sometimes can be revenue raising and sometimes not.
Yeah.
And so
if licenses can be revenue raising, and you can do this otherwise through revenue raising things, why wouldn't that capture tariffs?
So because I think, again, our point to you is that that there's two kinds of licenses come in 2 flavors. If an executive order is asserting a license fee to recoup the cost of government services or something like that, as I was saying to Justice Alito, that doesn't look different than the other verbs. That's not revenue raising. It doesn't implicate the founder's concern. It doesn't implicate the concerns you wrote about in consumers' research about the fear of the government.
Well, you're not answering my question, though, Mr. Koch. I'm talking about just the plain text here. And you're moving to a major questions or a non-delegate. That's the move you're making, which I think, you know, fine, we can consider that. I'm just talking about on the text, okay? It says by means of licenses or otherwise. You've conceded that licenses are economically equivalent to tariffs. And the statute says by means of licenses or otherwise.
Right.
Regulate.
It's only a means, and we looked at the history.
Yeah, it's a means.
Yeah.
Why isn't tariffs a permissible means on the statute?
Because, again, it has to be related to the 9 powers that.
Well, a license can be. We have to acknowledge that. And you've said a license can raise revenue, and you've said a license is equivalent to a tariff economically. So what about otherwise?
So, Justice Gorsuch, if the license or the otherwise is raising revenue, then it is a difference in kind from the other verbs. And we looked at the history of
These aren't verbs
licenses
either.
under TWIA, and we were not able to find any involving licenses or license fees.
Okay. Last question, a little further afield. The parties discussed a little bit the analogy to the Foreign Commerce Clause. Of course, next to it is the Indian Commerce Clause. And delegations there were very broad initially and involved licenses once again. And why shouldn't that inform our understanding of the Foreign Commerce Clause?
I don't know that I have a position on that. It maybe is a little too afield for me to.
Well, if the president has broad authority in one part of the Commerce Clause why wouldn't he in the next door neighbor?
Oh, I see. Because here Congress has specifically been given the exclusive power over tariffs. And so if they're to part with it, I think as this court has said in J.W. Hampton,
So
which
you'd
is a
say-
tariffs case.
You'd say the same principle would apply with tariffs with the Indian Commerce Clause. Is a tariff-specific argument?
I think it's at least intelligible principles is what this court has used for tariffs specifically, and we think that's the way you should look at this. And then under intelligible principles, this is miles away from any delegation we have ever seen.
Thank you.
Justice Kavanaugh?
Just on the Nixon point, because you said, I think, that the current tariffs are unprecedented. I mean, that was a 10% worldwide tax on every import into the United States, I believe. I mean, we don't need, I just think that's a fact. You have arguments about that. You made good arguments about that, but just wanted that point to be clear. On Algonquin, to pick up on Joseph Sotomayor's kind assist, your argument here is that the statute has to use the word tariffs, I think, basically. And we went through Nixon and Yoshida, but then Algonquin, the statute for 232, does not use the word tariffs. It uses adjust imports. And President Ford had imposed, again, a pretty significant tariff on oil imports. It was challenged. It got to this court. The attorneys standing where you are stood up and said the license fee now before the court involves the broadest exercise of the tariff power in the history of the American Republic. In fact, we would have to go back to George III's stamp tax to determine as broad an executive power as claimed in this case. The statute is a simple one. It does not mention the tariff on its face. The argument there was the word tariff was not mentioned, used to adjust imports. The court, obviously 9-0, rejects that argument, in part because, as others have pointed out, the court does a lot of questioning. Well, what's the difference between a quota and a tariff? And what's the difference between an embargo and a tariff? And so when the court writes the opinion, it says we find no support in the language of the statute, the language, for respondents' contention that the authorization of the president to adjust imports should be read to encompass only quantitative methods, i.e. quotas, as opposed to monetary methods, i.e. license fees, of effecting such adjustments. So on your basic point that you need the word tariff, Algonquin says you don't need the word tariff. And that was President Ford's oil imports. It's 9-0. The oral argument goes through this. Your answer.
There's a lot there, Justice Kavanaugh, so please bear with me. First, I'd like to clarify what our position is generally and then deal with Algonquin. Our position is not that you have to use the word tariff or any other magic word. It's true that Congress has used a specialized vocabulary since the founding, since 1790, using words like tariffs or duties. But as I was saying earlier to Justice Gorsuch, you could even use the word regulate, as our page 15 of our brief says. Or you could even imagine something that says, quote, the president may regulate importation by requiring importers to pay 10% of the value of goods to the Treasury. So I don't think you have to use any particular word. The question is in context, is it, does
Algonquin didn't have anything like that, but keep going.
So Algonquin does have, I think, a context that's miles apart from what the government is seeking here to do with IEPA. So first of all, it is a common sense statute. I understand there's some rhetoric by, common sense reading of the statute, I know there's some rhetoric by the lawyer who stood here before, which is of course forgivable. But it was a statute about one product. 232 is article by article. It's one product. This is a billion products or even more that the government is seeking. The Algonquin was expressly a trade statute. It was the 1962 Trade Act. It's everything this case isn't. Algonquin had a specific reference to the word duties in a separate provision. Algonquin had a legislative history that was clear as day that the president was given this power. And I understand this court today doesn't look to the legislative history, but the way Algonquin got to where it was by saying the legislative history, the chief sponsor of the act.
I think I'll disagree with you on that. It does a plain text and then says, is there anything in the legislative history to defeat the plain text? So I disagree pretty strongly with you on that, but it doesn't defeat your point. Keep going. Okay,
so I'd also say, maybe the most important point, 232, our argument is not just that you have to specifically authorize a tariff with some sort of word, but also that one way of understanding whether Congress is delegating its awesome tariff power, its awesome taxing powers, to ask, are there limits to what Congress has put in? And in Algonquin, in Section 232, the court points to and goes painstakingly through all the limits. The first words of the decision are all about how constrained the statute is. It's a reticulated scheme. The cabinet secretaries have to make certain findings. There are specific statutory factors Congress says the president must look at before acting. There are public hearings. There are limited remedies, quote, to the extent necessary. All of that is in the statute. All of that is in the Algonquin opinion. None of it is in IEPA. That's the problem, and that's why, just like James and Moore, the Algonquin case said this is a very limited decision, limited just to the facts.
Thank you.
Justice Barrett?
So this license thing is important to me. And do you agree that pursuant to IEPA, the president could regulate commerce by imposing a license fee?
I'm sorry, could you say that again?
Could the president regulate commerce under IEPA by using a licensing fee?
Not a fee. So I should have said this earlier, but license is different from a licensing fee. IEPA and TWIA authorize licenses, not license fees, and no president has ever charged, to my knowledge, fees under those two statutes for the licenses. So fees impermissible, licenses okay.
Fees permissible if they cover the costs of the scheme?
Might be. I mean, but once they start revenue raising, you implicate the most serious concerns.
But I thought you conceded to Justice Gorsuch there was no difference between a tariff and a licensing fee, functionally.
If the licensing fee is just to, I didn't concede that. So if the licensing fee is just to recoup the cost of government services, I think that may be okay. I don't think you need to get into it. Here, the government is asserting a power which they say in their briefs to you raises $4 trillion.
So you understand the statute to permit licensing in the sense of permission. Like, we will not allow you to trade with us. We will not allow your goods to be imported unless we license it.
Absolutely. And Justice Barrett, I think like just the natural reading, if you're to look at the word licenses and think, wow, Congress smuggled this incredible power to do all of these different things that the government is doing here, 39% taxes on some countries and others, through the word license, that's
Can you license exportation?
I don't think so, for the reason that,
Well, right now, I actually
Well, it
looked into
depends.
this. I mean, I think you, maybe not licensing fees.
Exactly.
But could you license exportation, like saying we're not going to allow certain products that have national security implications to be exported?
Yes.
So licensing could be used in that sense,
Correct.
not as a revenue raising measure.
Yes.
Okay. So you went back and forth with Justice Gorsuch about the implications of the president's authority over foreign affairs and whether the major questions doctrine applies. You say that in IEPA, the president's war powers are not implicated, and that was part of the reason why you say that we should think of this differently than some of the historical examples where the commander-in-chief power, war powers, were implicated. But the same language appears in the Trading with the Enemies Act, in which war powers would be implicated. So do you think the language should be, and of course that is what President Nixon relied on, so do you think that the language would be interpreted differently in that context, even though the commander-in-chief power and the war power would be implicated?
100%, I think, would be interpreted differently. Justice Jackson.
Same regulate commerce language.
Yes, because once you're carrying over wartime precedents to peacetime for
Okay,
reasons.
I don't understand that then, because everybody agrees the language came, in IEPA, came from the Trading with the Enemy Act. So you're saying it has one meaning in the Trading with the Enemy Act and a different meaning in IEPA, that same regulate commerce?
No, I think that the conquered territory language and all of that may go to the president's Article 2 powers, his inherent powers in conquered territory, but I don't think it gets the government where they need to go. The CAC brief and the brief by Professor Paul Stephen goes through and explains why in 1933, when Congress decided to bring these concepts into peacetime, it severed the wartime roots. And there's an extensive legislative history.
Okay, I understand that, but I thought that was about, maybe I'm just not tracking. I mean, I think there's been some discussion of whether the president would have inherent Article 2 authority in wartime to impose tariffs to this end. Is that what you're talking about? Are you actually talking about a statute that said regulate importation in wartime?
Right.
And you think it could have the tariff power conferred through that language in a war-making statute, but not an IEPA?
No, I don't think it confers it in either place. I think the president, it's located, the president's power in conquered territories, not in the Trading with Enemies Act or anything like that.
Okay, so it's
but
an
rather
inherent constitutional
Exactly.
power coming from the law of war. Okay. And then if you win, tell me how the reimbursement process would work. Would it be a complete mess? I mean, you're saying before the government promised reimbursement, and now you're saying, oh, well, that's rich. But how would this work? It seems to me like it could be a mess.
So the first thing I'd say is that just underscores just how major a question this is. The very fact that you were dealing with this with quotas, there's no refund process to the tunes of billions of dollars or embargoes, but there is here. But for our case, the way it would work is, in this case, the government stipulated for the 5 plaintiffs that they would get the refunds. So for us, that's how it would work. Your question, I take it, is about everyone else, where you don't have a class action or anything like that. With respect to everyone else, there's a whole specialized body of trade law, and it's in 19 U.S.C. 1514 outlines all these administrative procedures. It's a very complicated thing. There's got to be an administrative protest. There was a harbor management case earlier that this court was involved with in United States Shoe, in which the refund process took a long time. There were any number of claims and equitable relief.
So a mess.
So it's difficult,
Okay.
absolutely. We don't deny that it's difficult, but I think what this court has said in the McKesson case in 1990 is that serious economic dislocation isn't a reason to do something. Northern Pipeline, you guys stayed your decision for a while in order to let the congressional process unfold. There may be a congressional process here as well. You may be able to also be that this court could limit its decision to prospective relief under the John Q. Hammonds case. So there's lots of possibilities.
Justice Jackson?
So I think I read Algonquin differently than Justice Kavanaugh. When I look at its analysis, it absolutely does a textual review, but then it says, quote, turning from Section 232's language to its legislative history, again, there is much to suggest that the president's authority extends to the imposition of monetary exactions. And I appreciate that perhaps that factor is no longer in vogue, but did you look into the legislative history here to determine whether there is anything that supports the conclusion that Congress actually intended for this IEPA statute to allow or authorize the president to impose these tariffs?
I did, and if I blinked, I would miss it because it was virtually nothing. And in fact, both page 2 of both the House and Senate report outline all of the powers that are given under IEPA, and none of them have tariff. There's one brief mention of tariff in the legislative history, but nothing else. And by the way, IEPA passed by voice vote. It was, there was not controversial. We don't deny IEPA as a big, major statute, but the question is, did it authorize tariffs? One of the most contested things since our founding.
And you say there's nothing in the legislative history to suggest it. Now, to the extent that Congress did authorize the president to do something, that those verbs are there, that the Congress was giving the president some authority, do you see a theme connecting those verbs? What was Congress trying to do? And let me just say that I see in the Senate report, which I mentioned earlier, that Congress says that it was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And that seems to dovetail with the verbs that are being used in the statute, but what's your view of what Congress was trying to do with this legislation?
That's exactly right. They're responding to all sorts of foreign policy emergencies and foreign threats, and they're giving the president economic sanctions power.
So what does the word regulate importation do under that framework? If we understand that Congress was trying to give this kind of embargo authority in the time of an emergency, when it says regulate importation, what was it envisioning?
It was envisioning all the things that the president since 1977, going back to Justice Kavanaugh's question, have used it for. So they've used it for quotas, like limitations on the number of goods. They've used it for screening and reporting requirements, like Executive Order 12284 about reporting property of the Shah. And they've used it for standards, like domestic safety standards, environmental standards, labor requirements. They've used it for embargoes. So all of those are things that I think Congress had in mind in IEPA, and I think the proof of this, that it's not this massive statute that allows the government to do anything, is Dames and Moore itself, because this court rejected the idea that regulate includes the claims extinguishment that was at issue in that case. It's a much more limited statute. And Justice Jackson, there was a predecessor, Justice Jackson, who said, that, quote, for all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, but it is the duty of this court to be last, not first, to give it up. And I take it my friend's argument on the other side is in deep tension with Youngstown and that canonical principle.
Thank you.
Thank you, counsel. Mr. Gutman.
Mr. Chief Justice, and may it please the court. I'd like to begin by picking up with the exchanges with Justice Barrett and Justice Gorsuch about licenses and license fees, because I think we ended on the right note, but I just wanted to make sure that at least my client's position is clear on this. Licenses are different from license fees. And I am not aware of any history in the 5 decades that IEPA has been in force of any fees charged for the licenses under this statute. This is a statute that licenses can be used, for example, the president might ban certain transactions with a foreign country, but then grant licenses to do them for humanitarian reasons. But as far as I'm aware, there's never been a fee charged for that. And I do welcome the court's questions. But I think I just want to make absolutely clear.
I think the question is, what does or otherwise do?
Well, or otherwise could be of things like instructions or licenses, but again, it's fundamentally having something that is a revenue-raising measure or even that is just an exaction of some sort is fundamentally, categorically different from what we understand instructions and licenses to be involved, just like we think regulate doesn't carry the financial connotation given the other verbs there. If I could turn to some of the 19th century history that we were discussing as well, because I think there may be a little bit more to add there. The 19th century cases about the president's inherent Article II authority to, with respect to, in a wartime, with respect to importation is not the power to impose tariffs on imports coming into the United States. That is not what any of those cases were about. They were about the president's power, in a wartime as an occupying military force to impose tariffs in occupied territory, that in Mexico, in the Philippines, in California. The Civil War case might be the closest case, but even there, what we were talking about were essentially, there were licensing fees, but they were export fees. They were fees that were being imposed on the exportation of cotton from the occupied South into the North. And so I don't think any of that provides authority for this general notion that there is a background principle that the president, even in wartime, has an Article II authority to impose tariffs, certainly without the consent of Congress.
So you agree, I assume, given all the verbs in this list, that the president could do something like just shut down all trade between us and, say, China, right?
Yes, I mean, there are other limitations in the statute.
Okay, so doesn't it seem, and I think this is one of the points that Algonquin makes, and I think it's a point that Justice Kavanaugh was making, doesn't it seem then, I mean, I don't want to use the phrase lesser power, lesser included measure, but doesn't it seem like it would make sense then that Congress would want the president to use something that was less, weaker medicine than completely shutting down trade as leverage to try to get a foreign nation to do something?
And the president can in the form of, for example, quotas. But what makes an embargo or quotas fundamentally different from tariffs, as my friend has already explained, is the revenue-raising aspect of that. That makes it a far more significant power. It creates additional danger of overuse. And I think the other point, as Justice Jackson was pointing out, is that it cedes control over whether the transaction occurs from the government to the individuals engaging in this transaction. And that is not what IEPA is intended.
What makes something revenue raising? I mean, fees raise money, and unless they're going to be kind of one-to-one, this is exactly what it costs. I mean, it might raise some surplus. It might raise some extra. So is it the purpose? If the purpose of the fee or the tariff is to raise money, is it the purpose that makes it revenue raising, or is it just the fact of surplus created that goes to the Treasury? Like, how do we decide this?
Yes, I think it's the effect. And to be clear, I think there would be a serious difficulty with interpreting any of these words, even to allow revenue neutral exactions here, because none of them, and again, as far as I'm aware, IEPA has never been used in that way. But I don't
Not even a processing fee?
I am not aware of any use of that sort of under IEPA. But even if that is permissible, I think that's permissible precisely because it doesn't have the effect of raising revenue.
Mr. Katyal referred to common sense several times, and I want to pick up on Justice Barrett's question because your interpretation of the statute, as she pointed out, would allow the president to shut down all trade with every other country in the world, or to impose some significant quota on imports from every other country in the world, but would not allow a 1% tariff. And that leaves, in the government's words in its brief, an odd donut hole in the statute. Why would a rational Congress say, yeah, we're going to give the president the power to shut down trade? I mean, think about the effects. But you're admitting that power's in there.
Yeah.
But can't do a 1% tariff. That doesn't seem, but I want to get your answer, to have a lot of common sense behind it.
I think it absolutely does because it's a fundamentally different power. It's not a donut hole. It's a different kind of pastry.
And on that power, that's a good one. On that power, though, and you've said this many times, and Mr. Katyal too, and look, I get this, obviously, but the court has repeatedly said a tariff on foreign imports is an exercise of the commerce power, not of the taxation power. And I'm repeating some, but John Marshall said that, and Joseph Story, and Chief Justice Hughes in the 1933 case, and we've said that quite a bit of time, which seems to at least undermine a bit your point that it's an entirely different power, because if it is foreign commerce power, it's the same power that Justice Barrett was talking about of just embargoing trade with the entire world, which you admit is in this statute.
Well, there are a couple of points in there, and I'll try to get to all of them, but I mean, I think all of us agree that context is what matters here, and that you certainly could use the word regulate to talk about a tariffing power, like you could use it to talk about a taxing power. I mean, we impose taxes for regulatory purposes as well. But the federal government hasn't identified a single other federal statute that uses the term regulate to authorize tariffs or taxes. That is just a different kind of power.
And I thought your point in response to Justice Kavanaugh, it's a different kind of power because the power that's being authorized by this statute is the power to control or freeze trade. That's what Congress was getting at. And so if that's true, then we have to read regulate in that context.
That's exactly right. And I think the reason, getting back to common sense as to why a legislature might authorize that, is that you might not fear abuse of that power in the same way that you would be concerned about abuse of a power to impose unlimited taxes with sort of no controlling principles.
Well, why is that? Because, I mean, there is a sort of commonsensical intuition that one is, in Justice Kavanaugh's example, that one is greater and one is lesser. So why is that not right? Because, to be blunt about it, there's nothing, one of them there's something in it for the government and one of them there isn't. Actions that bring in revenue from the pockets of taxpayers to the Treasury pose a different set of concerns. Our framers were very concerned about that. A different set of concerns, how, why? Because they bring in revenue. And because that creates
Well, that seems a little tautological. Like, why is it that the revenue raisers are in a different category?
Because if there is some sort of international emergency and the appropriate way to deal with it is to make sure that no more than 1,000 of this product comes into this country at a particular time, this statute gives the president the power to ensure that exactly no more than 1,000 come in at this time. Setting a tariff doesn't ensure that only 1,000 will come into this country. It cedes control over whether the transaction occurs. And what it does is it then adds revenue to the Treasury, and that is again something that our framers thought was extremely important and a core Article 1.
But Algonquin, I mean, this kind of goes back to Justice Kavanaugh's point. Algonquin rejects the idea that it was impermissible to use the fees, and we can call them, license fees that functioned as tariffs or duties in that case, whatever. But Algonquin said that Congress could use the exaction of money to control quantity. And I hear what you're saying is like, well, you can control quantity by numbers by imposing hard limits, but not by money. But that's not what Algonquin said. So I guess, why?
Well, and I don't mean to suggest that you can't use exactions to control quantity. What I think Algonquin just shows the importance of context. It might be perfectly natural to read a phrase like adjust imports in the context of a statute that talks about tariffs, in the context of the Trade Expansion Act, that has all sorts of provisions about tariffs and about the president adjusting tariff rates. It might be perfectly natural in that context to read a phrase like adjust the imports to be referring to changing tariff rates. It's just as unnatural to read a phrase like regulate importation to discuss that when the statute has nothing to do with tariffs and doesn't otherwise mention tariffs at all.
And do you think imposing tariffs is do you think that just blocking all trade is a bigger deal than imposing a 1% tariff across the board?
I think it would be a huge deal. It is just a different kind of deal.
Algonquin was not a constitutional case, right?
Correct.
It was a statutory interpretation case.
Correct.
And so the question there was simply, was Congress actually trying to give, or did Congress in that statute give the president the authority to impose these kinds of exactions? And the court looked at the text, and it looked at the legislative history in which there was a number of clues that Congress had actually intended to do that.
Yes, yes, and it looked not just at the text of those specific words, but also the context of what else was in the statute and the fact that some of the factors that the president was supposed to be considering.
Keep going.
And it would make perfect sense, I think, in a time of emergency for many of the reasons that General Sauer pointed out, that Congress would want the president to have the kind of authority that is imposed when you are embargoing things, when you are stopping the trade, when you are saying, for emergency reasons, we're not letting any of this product come in. I mean, sure, that's a big deal, but the nature of it makes sense in terms of an emergency. I think what you're saying is that the idea that the government would use its authority to be raising revenues in this situation is a different kind of power.
Exactly. This is a statute about giving the president control over assets, over transactions, over access to banking.
And tariffs don't do that. You said something about
exactly
tariffs
right.
tariffs in fact cede control
Exactly
over
right.
those sorts of things. So they sort of undermine the goals and the purposes of this kind of statute. Is that right?
Yes, that's exactly right.
From
I ask-
what you said,
Go ahead.
From what you said, it seems, and you said this, that the reason for drawing a distinction between tariffs and an embargo is the suspicion that tariffs will be used to raise money and therefore to circumvent Congress's power to control taxes. So it's a question of the risk that's involved. Am I right?
Yes.
That's what it boils down to.
Yes, well, and it's a question of understanding what Congress would have thought, what powers Congress would have thought it was conferring. Would Congress have understood the phrase regulated?
Well, I mean, the question is, why would Congress say you can impose a quota, you can impose a ban, but you can't impose a tariff? And your answer, I gather, is because when a tariff is imposed, we're suspect about what's going on. We're suspicious about what's going on. We think that what the government is trying, what the executive is trying to do is to raise revenue, and that's our business, right? That's what it has to be.
Yes, and we know that every other time that Congress has authorized the
Well,
president.
that's it. You know, you're getting into a different argument. Then would you say the same thing if the measure is really about an emergency, an
Yes.
undisputed emergency and a really dire emergency?
Yes,
Would you have the same suspicion?
Yeah, yes, absolutely. And again, I'll refer back to Justice Jackson's concurrence in Youngstown that emergency powers tend to breed emergencies. Look, Biden versus Nebraska, I think, says very clearly.
I really don't think you're answering the question. The question is, would you have the same suspicion when it is perfectly apparent from context that what the president is trying to do is to achieve a goal other than the raising of money?
I think what I'm trying to say is that you have to read the statute the way that Congress would have understood it when it was enacted, not how it is used in any particular case. It may be used for very good reasons in a particular case, but the question is, would Congress have understood itself to be ceding this power with no limits, unlike every other tariffing statute with no
All right,
limits?
I know that point. Let me ask you an unrelated question. Mr. Katyal listed some of the things that presidents have done under IEEPA, such as screening imports. Do any of the other verbs in IEEPA talk about could screening of imports be done under any of the other verbs in IEEPA?
I think maybe, but it would have been...
Which one?
Prevent. And so I think the question would be,
Screening is preventing?
Well, I think it depends what you're screening for, but if you were...
Okay, how about imposing domestic requirements that are needed to safeguard domestic safety? Any other provision besides regulate? Any other verb besides regulate that would...
Well, again, I think if we're talking about potentially blocking some property from coming into this country because of safety concern, it might be that prevent would have gotten you there. What I think regulate does is it clarifies and amplifies that you don't just, it can be nuanced in that way. It can say, we will let this come in if it has certain safety requirements, if certain features have been disabled, something like that. And I think regulate harmonizes with prevent, investigate during the pendency, block during the pendency of an investigation, those sorts of...
On the context point, the context of this statute, what Congress would have understood, it's an emergency statute. And presumably Congress wants to give the president tools to respond to the emergency in an appropriate way. And it seems odd to imagine a meeting in the Oval Office where the president's told, well, we have a problem with, I won't name a country, but country X, and you can stop all trade with that country. I mean, I'm not sure that's a, wise policy to give that much, but it's there, right? You agree it's in this statute. But, and the president says, well, that's too extreme. I want to calibrate my response to deal with this, and maybe a tariff of some kind. Like, oh, you can't do that. So you're forcing the president to respond to an emergency. And, Justice Alito's raised the point about, a real emergency. And you're taking away the president's suite of tools when the one is much more extreme that is authorized. That just seems a bit unusual. Think about India right now, the tariff on India, right? That's designed to help settle the Russia-Ukraine war, as I understand it. Don't pretend to be an expert. But if that's gone, that's a tool that's designed, talk about foreign facing, the most serious crisis in the world. And that's out the window. So I just think it's just contextually emergency. It's just a bit unusual to read it that way. But I take your response. Taxation's different, and you got to stick with that line.
No, and I don't think it's just that. Because I do think it's that, but it's also that there are a range of tools that are more calibrated that the president can do. It doesn't have to be a complete embargo. It could be limits on particular kinds of products. It could be quantity,
I get it,
quality.
but in the history of trade efforts to respond and push back, You're taking one away.
Well, and the president, and there are many other statutes that might apply depending on the
get
exact
that.
circumstances,
Fair-
201,
that's-
301, 232.
Counsel, I
That's a good
think what
point.
we're forgetting here is a very fundamental point, which is the Constitution is structured so that if I'm going to be asked to pay for something as a citizen, that it's through a bill that is generated through Congress and the president has the power to veto it or not. But I'm not going to be taxed unless both houses, the executive and the legislature, have made that choice, correct?
That's exactly right.
And so there is something, it's not just the taxing power, qua taxing power. The question is, do we permit the president to use the taxing power to affect his personal choices of what is good policy for me to pay for?
That's exactly right. The question is who decides.
Who decides and under what circumstances? Now, with respect to this, I mean, I'm not even going to the pretext argument, okay? But the president threatened to impose a 10% tax on Canada for an ad it ran on tariffs during the World Series. He imposed a 40% tax on Brazil because its Supreme Court permitted the prosecution of one of its former presidents for criminal activity. The point is, those may be good policies, but does a statute that gives, without limit, the power to a president to impose this kind of tax, does it require more than the word regulate?
Exactly.
That's your point.
Yes.
Thank you, counsel. Did Mr. Katyal say anything this morning with which you disagree?
No, I think we cleared up any maybe potential disagreement about licensing fees, but I think we all agree on that.
Okay. Justice Thomas? Anything further? Justice King?
Briefly.
Justice Gorsuch?
Chief. So I just want to follow up on Justice Sotomayor's question at the end of a long morning, afternoon. It does seem to me, and tell me if I'm wrong, that a really key part of the context here, if not the dispositive one for you, is the constitutional assignment of the taxing power to Congress. The power to reach into the pockets of the American people is just different, and it's been different since the founding and the Navigation Acts that were part of the spark of the American Revolution, where Parliament asserted the power to tax to regulate commerce. Some of those were revenue raising, some of them didn't raise a lot of revenue. We had a lot of pirates in America at the time. And Americans thought even Parliament couldn't do that, that had to be done locally through our elected representatives. Isn't that really the major questions, non-delegation, whatever you want to describe it, isn't that what's really animating your argument today?
I think it's a huge piece of what's animating our argument. Thank you.
Ms. Kavanaugh? Justice Jackson?
Can I just invite you briefly to address your kind of second-tier arguments, assuming that the president can impose these sorts of tariffs? Why do you think, for example, that the trafficking tariff here does not deal with the drug trafficking emergency for the purpose of this analysis?
So it doesn't deal with it because it's not a sanction imposed against traffickers. It is, if you think of it as a sanction, it is a sanction imposed against people importing lawful goods in the hope.
Doesn't that that happens all the time, right? I mean, all the other authorities indirectly provide leverage on countries in this way.
I don't think so. I think that they are, the history of IEPA and even of TWIA is imposing sanctions directly on the wrongdoers. These are statutes about providing sanction authority against international actors whose behavior we want to change, and that's not what tariffs.
All right, thank you.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. Just 3 points. One, an interpretive point. The statutory language here is regulate importation, and again, by means of instruments, licenses, or otherwise. Their argument is that that phrase carries with it a whole host of unenumerated forms of regulation, including quotas, licenses apparently that come with fees as long as they're sort of profit neutral fees, environmental restrictions, qualitative restrictions, reports, and so forth. It's just that the one form of regulation that they would not include is tariff regulation, which of course is the quintessential, most historically tested method of regulating imports. And so that additional phrase about, by means of instruments, licenses, or otherwise, really sort of reinforces the plain meaning, the ordinary, natural meaning of regulated importation here. So when it comes to just the plain text of the statute, their argument is a donut-type argument, and it's not an argument that does justice to the statute's plain text. On the non-delegation point, Justice Gorsuch, you alluded to the founding or delegations of the Indian commerce power, and I just remind the court that in 1790, in July of 1790, Congress passed a statute that essentially delegated to President Washington essentially the entire scope of the Indian commerce power. He said you can do commerce with Indians if you have a license that you had to pay a fee for, and that will be subject to such rules and regulations as the president makes with no further guidance. So when it comes to this foreign-facing there, it's obviously analogous because it's the Indian tribes, not foreign sovereigns, but this foreign-facing situation, we have a very sort of deep and profound historical pedigree through broad delegations of the regulation of commerce, right? The foreign commerce power, in that case, the Indian commerce power. And that ties, I think, to what I take to be the main theme of the arguments on the other side. And I think that Mr. Catchall started by saying tariffs are taxes. And I want to complete the answer I think I was giving to the Chief Justice when I got interrupted is, if you look at these tariffs, these policies, it is clear that these policies are most effective if nobody ever pays the tariff. If it never raises a dime of revenue, these are the most effective use of this particular policy. And I said there's two buckets there. One is, first of all, when it comes to the trade deficit emergency, if no one ever pays the tariff, but instead they direct their consumption domestically and spur the creation of the rebuilding of our hollowed out manufacturing base, that directly addresses the crisis. It's more effective if no one ever pays the tariff. That's the point of it, really. That's a fundamental point of it. And that's one piece of these. And then as to both of them, as to both of the declared emergencies, the tariffs are an incentive, a pressure point, leverage, bargaining chip, as the court said in Dames and Moore, to get countries to change their behavior to address the foreign arising emergencies. So if you look, for example, to take a historical example, last week's trade deal with China, it unlocked access to rare earth minerals, which of course have a critical national security aspect to them, and it got China for the very first time to change its policy with respect to fentanyl precursors, which is a crucial piece of that. Those tariffs, if no one ever collects them, but the threat of imposing those tariffs gets China and our other trading partners across the world to change their behaviors in a way that addresses this, then that's the most effective use of the policy. So they're clearly regulatory tariffs, not taxes. They're not an exercise of the power to tax. They are the exercise of the power to regulate foreign commerce. And that's why the statute says regulate. It doesn't say tax. It says regulate. And for that reason, we are squarely within the tradition that I was talking about before of very broad, historically very broad delegations of the power to regulate foreign commerce to the president because he has inherent article of authority in the area of foreign affairs, although not that. It has to be delegated to him, otherwise the delegation would be superfluous. And for all those reasons, we ask the court to reverse both the decisions below.
Thank you, counsel. The case is submitted.
say only Congress has the power to impose tariffs on the American people, then tariffs are nothing but taxes on the American people, paid by Americans. This case is not about the president, it's about the presidency. It's not about partisanship, it's about principle. And above all, it's about upholding the majestic separation of powers laced into our Constitution that is the foundation for our government. We thank the justices today for their extensive questioning in this case, and we look forward to the resolution.
Thanks, Neil. Good afternoon. I'm Sarah Albrecht from the Liberty Justice Center, and I have the pleasure of working with Michael McConnell and Neil and our private plaintiffs on behalf of all small businesses in the United States. We are very proud to have brought this case to challenge unlawful and unconstitutional tariffs that are devastating small businesses across the country. Like all Americans, we are endowed with the right to take our government to court when it violates the law or defies the Constitution. In this case, it did both. These unilateral tariffs imposed without congressional authorization are unlawful. IEEPA does not permit the president to issue this kind of sweeping arbitrary tariffs at issue in this case. They're also unconstitutional. Tariffs are taxes, and the Constitution grants taxes to Congress, not the president. Our founders designed a system of separation of powers to prevent exactly this kind of unilateral, lawless action. We thank the court for their time and look forward to the resolution of this matter.
Hi there, everyone. Thank you for coming today. I'm Victor Owen Schwartz, founder of VOS Selections. For nearly 40 years, my family has built this business from the ground up. Today, reckless tariffs threaten everything we've achieved. Let's be clear. These tariffs aren't paid by foreign governments or companies. It's American businesses like mine and American consumers that are footing the bill for the billions of dollars collected monthly by our government. Unlike past tariffs set by Congress that we could plan around, these new tariffs are arbitrary. They're unpredictable and they're bad for business. They throw my family business and thousands of others into chaos. The pain has been felt across the country, from warehouse workers and truckers to retailers and restaurateurs. That's why I joined this lawsuit. I was shocked that those with more power and money did not step up. The reason I was able to file this case is because the Liberty Justice Center did step up and offered 100% pro bono legal services to me and other affected small businesses. When I was given the chance to speak up for small American businesses, I took it. I had to. Our very survival is at stake. I'm grateful to the Liberty Justice Center and our legal team for their vigorous advocacy. And I urge the court to recognize the real harm these tariffs inflict on American families and businesses. Thank you.
Thank you, guys.
Can you confirm that John Mulaney was there because he's your friend?
Thank you.
because the corporation, because of the United States versus the Federal Commissions Committee, Federal Communities Committee, sees that there is no limit to what these corporations can go into a politician. If I'm a politician, who's the picture am I going to put on the agenda?
Well, good afternoon, everybody. My name is Dan Rayfield, Attorney General for the state of Oregon. We're proud to bring this case today. I think there was something that was incredibly important that was said today, and it wasn't said by any of our attorneys. It was said by President Donald Trump's Solicitor General when he looked Justice Roberts squarely in the eyes and said the American people, not foreign countries, but the American people are going to pay 30 to 80% of these tariffs, and then had the gall to look all of those justices again in the eye and say that these are not taxes on the American people. And they're doing it by abusing an emergency power. And I think that was the conversation that we heard today. Very proud of our attorneys and proud to have these amazing partners in AG Mays and AG Bonta along in this incredibly important fight when America's facing an affordability crisis.
Thank you, A.G. Rayfield. I'm Chris Mays. I'm the Attorney General of Arizona, and I would just echo those comments. This was, we feel really good about the arguments today and the questions that were asked by the justices. But, you know, we brought this case, and this case is so important. Maybe the most important case that this court has heard in 100 years, especially to our economy and to consumers and to businesses large and small. And that's why we brought this case, because number one, these tariffs are illegal. They were not predicated in the law or the Constitution, but most importantly, they are impacting the people of our states. We have small businesses in Arizona that are going out of business every day. I've talked to a furniture manufacturer, a restaurateur, a hotel owner, cattle ranchers along the southern border of Arizona, all of whom are struggling because of these tariffs and because they are raising prices on the people of this country. And so we needed to come here and we need to win this case, and that's why we're here. We appreciate the opportunity to make these arguments, and I'll turn it over to my colleague, Rob Bonta.
Thank you, everyone. Rob Bonta, California Attorney General, and grateful to be here with my colleagues on behalf of the states that have brought suit to support the American people who deserve better, who deserve to not have costs raised, who deserve to not be the victims of unlawful tariffs. Tariffs are taxes. Congress has the power to impose taxes. The president does not. He has used tariffs in a sweeping manner to impose 10 to 145% taxes on nearly every one of our trade partners, and workers are suffering, businesses are suffering, families across the country are suffering because of his unlawful conduct. And California is the fourth largest economy of the world, the biggest state in the nation. We are the largest importer of any state, the second largest exporter, the largest exporter of ag. We're the biggest manufacturer. We have an outsized economy, so these tariffs have an outsized impact on the people of our state and on our state. So I thought the argument surfaced all the key issues, and we are hopeful for a decision. We won't predict or speculate about what might happen, but I thought it was a great argument, and we hope that when the decision is made by the Supreme Court, we will be able to deliver the relief that Americans deserve, to have their costs lowered and not have a president who acts brazenly and blatantly in lawless manners, as he has done with the violation of the law here, when he has no statutory authority to impose these taxes. And we're happy to answer your questions.
Attorney General Mays?
Yes.
You joined or filed 30 different lawsuits since January, since Trump came in for a second term.
Rob's filed more. So is Dan, but anyway. But who's counting?
You mentioned the impact this could have on everyday Arizonans. What's at stake if this lawsuit in particular, when it comes to tariffs, isn't successful?
Yeah, I mean, I think all three of us feel a very heavy burden today because we know that we have to win this case. What is at stake for the state of Arizona, like all the states, frankly, is that prices, if we don't win and these tariffs are allowed to stay in place, prices are going to continue to go up. These are taxes. Americans are now dealing with an average 17.5% national sales tax because of these tariffs. That's what this is. And so what's going to happen is consumers are going to continue to pay more. It's going to be a really rough Thanksgiving. It's going to be a really rough Christmas and holiday season. And our small businesses are going to continue to go out of business if these tariffs are allowed to stay in place. And so the stakes of this particular argument could not possibly be higher for our country and for our economy.
I'm Genius Fly with Citizen Evening News. Could you share a little bit more about what the justices said today about the major question doctrine?
I mean, I'll take that first, but I thought it was really interesting. There were obviously multiple justices who raised the major questions doctrine issue. This is a court that has, favored the idea that when an agency does something that is extraordinary and major, it cannot do so without going to Congress first. And a couple of the justices compared the tariff scheme that Trump put in place to a major question or the major question doctrine. I thought that was a really good sign. We'll see. Again, we're not going to predict anything, but I thought it was a good sign for the plaintiffs, for us.
Speaking of all those dozen of cases, some critics argue that some of your lawsuits are favored by the partisan motive. How do you respect that?
By what?
Partisan motive.
Oh, look, and I'll let my colleagues answer this too. Our lawsuits are driven by the law and by the Constitution. Look, is it on my bucket list to sue Donald Trump? Absolutely not. This is not what I get up every day wanting to do. But if Donald Trump decides to violate the Constitution, violate statute, or harm the people of Arizona, I'm going to file that lawsuit. And the 30 lawsuits that I have entered the state of Arizona into have saved the state of Arizona $1.5 billion. And it's interesting that the Republican AGs
Is the Constitution or law being violated? If the answer to those two questions are yes, we're filing a lawsuit. And what everybody should know is in all of these cases where we've sought immediate relief, we've been overwhelmingly successful. Look at this tariff case right now. We have judges that were appointed by Trump, multiple judges, that ruled in our favor because these are foundational principles of how our democracy is put together. And I think you saw that here today. That a lot of this stuff, it doesn't matter where you come from, whether you're a Republican or a Democrat. These are incredibly important issues that are affecting all of us. Right now, it's our pocketbooks.
Justice Alito mentioned the irony of the Ocasio arguing in favor of the non-delegation doctrine. If you could speak to the broader irony of having a Republican president arguing in favor of what is arguably tax increases and Democratic lawyers arguing using the major question doctrine and non-delegation doctrine and just kind of the broader kind of inversion of flavor.
I mean,
you'll see
I would just say that
you'll see them. And the greatest athletes will be on the stage.
We're in the world of the upside down, right? You have Stranger Things, right? We're in the world of the upside down. If you go back to Ronald Reagan, and Canada was doing this, right? They're literally putting ads on TV of Ronald Reagan. And then our president, gets incredibly sensitive. He's thin-skinned, and then all of a sudden he increases tariffs again. What a better argument for what's going on right now. But effectively, tariffs can be a very helpful tool in trade. When you have someone that's trying to manipulate markets, we want to have fair, balanced competition. But in a case right now where we're being used punitively, where there aren't emergencies and they're taking powers away from Congress, that's what this is really about. So I see consistency in how we're using this case and how we're using this in the impacts of tariffs. Very consistent, but it is odd to me to have free trade out, and you have the Canadian government using, the standard bearer for the American Republican Party, Ronald Reagan, against themselves.
I mean, can I just add to that? I'm a former Republican, okay? I'm a former Republican from the great state of Arizona, It is insane and bizarre that we have a president of the United States right now who is engaged in an almost 18% national sales tax that violates the Constitution and violates federal law. So this is not the Republican Party that I used to belong to at all, ever. It is not something that Republicans used to believe in, but they are now allowing it to happen out of the White House and saying nothing about it at Congress, in Congress.
You're right, Bill. You only got one question about remedies from Justice Barrett. I'm wondering what you made of that question generally, and what specifically you think what inadequate remedies look like from this court in this case.
When I think about remedies of what this president has done, because I'm absolutely positive that his lawyers looked him in the eyes and said, hey, what you're doing is debatably not constitutional. You debatably don't have the power to do it. And he did it anyway. And he did it in a way that our small businesses and consumers and everybody across this country are paying for the bill. I teach my son, when you screw up, you make it right. And I believe that's what the president needs to do.
So what specifically does that look like? Like a refund for all Oregonian importers? Or what exactly were you hoping that really looks like here?
No, the implementation of how you make it right needs to be done in a conversation with the appropriate government agencies. In a perfect world, right, if you paid a given tariff out as a small business, especially when you've got small margins to get through each month, that money should be repaid back.
I just want to make a comment about state AGs who have come together. First, I want to say I'm very proud to be with this incredible coalition of AGs who have together brought over 50 cases. I want to also say that we're winning over 80% of these cases, so we're prevailing. We don't ask ourselves a partisan question, we ask ourselves a legal question. Is the president breaking the law? That's the only question. If the law and the facts indicate that he is, and he's hurting our states, then we sue him. If the facts and the law indicate that he's complying with the law, we don't sue him. We don't want to sue him. We hope that the president will follow the law. Not a lot to ask that the president of the United States of America follow the law and comply with the Constitution, but he is repeatedly breaking the law. And so we meet him at the boundaries of his authority, and we say, you shall not cross here, you cannot pass here, you cannot move beyond this authority and do unlawful things, you can only do lawful things. And so that's why we're here today. And the unlawful action that he has taken is hurting the American people, hurting the people in our states, hurting businesses, families, and workers, and we're here to make things right, and hopefully we'll get a remedy from this court. Thank you.
If the president uses Section 338 to impose similar tariffs, are we going to be back here in a few months?
We'll have to see what he does next. This, as the advocates for the states and for our side had indicated, this is about whether he has the authority under IEPA. He doesn't. So if he's going to impose, maybe he'll say, I'm not going to impose any tariffs. I was unlawful, you stopped me, I'm done. Maybe he'll say, I will come back. We'll have to assess what he does and what they look like, and we'll have to match his actions to the law to see if it complies. Again, if it doesn't comply, we'll sue him. If it does comply, then he may do lawful things, as I've stated. So we'll have to assess what he does next and decide our next action based on that assessment.
Did we tire you out?
I'm also prepared if the Supreme Court rules, or do you agree with you? Let's come back up as well, or is there anything else you can do?
So I think the question was, do we have a backup plan if the Supreme Court doesn't rule our way? And so I think we all feel like we're going to wait for this court to rule. We feel good about the arguments that were made, and we feel good about the questions that came back from this bench. And so, yeah, we are hoping for a positive result. We are hoping that this court will decide that the administration violated the Constitution and IEPA. And, you know, we'll cross that bridge when we come to it. But I'll tell you what, these tariffs need to go away. We needed to slay this dragon called tariffs or taxes because the people of this country are hurting. They are now laboring under the triple whammy of ACA price increases, SNAP benefits not coming through in Thanksgiving, and tariffs that are driving up inflation. We need to win this case, and we're really hoping that we do.
Thank you. We got time for one more question, one or two.
Thank you, Rachel. Do you know Mr. Gutman practice the donut hole pastry blend? Is that on the fly?
It's actually dominated the last month of our interaction. We were like, do we want to do a croissant? Do we want to pronounce it the way that the French pronounce croissant? Are we going to stay American and are those croissants tariffed? A lot of questions that we've had over the last month to prepare for this moment in time. Yeah.
The other lasting courtroom was over the non-delegation doctrine. It's been so long since it's been brought up. Tell us how long it's been. I mean, it's been just like a new conflict, right? We had to deal with this conflict between branches.
Yeah, I mean, I think that's true because it's been a long time since we've had a president who was willing to violate the Constitution on a near weekly basis. And so we are seeing concepts come up like the non-delegation doctrine, like separation of powers, that haven't been a problem for hundreds of years or certainly decades. And so, you know, yeah, the Supreme Court is having to grapple with these concepts, and we are having to file lawsuits based on them because no president has violated the law and the Constitution as much as this one has.
Last question.
General, you mentioned consistency before. Just to follow up on the question before, do you see consistency in how Democratic attorney generals and governments have applied the major question doctrine previously during the Biden era and now?
Yeah, and I can't speak to how prior AGs have applied the major questions because people have been on both sides of this fence throughout the way. But what we talk about is what is the current structure of our case law here in America today. That is what needs to be applied to the rules that are going on right now. And the truth of the matter is you heard them today talk about that $4 trillion of tariff revenue. If you use even 25%, that's lower than the math that they told the justice. That's a $1 trillion hidden tax on the American people. $1 trillion. And there wasn't a single vote taken in that building over there. And that's what the Constitution requires when you're raising revenue in this country. And right now, if you allow this, the president to continue to do this, you can raise taxes on anything. Hidden taxes left and right on any good, any amount, for any duration, and all of us are going to pay the cost. That's why this is so important, and kind of getting back to the question. If we were to lose this case, it's an important conversation for the American people to say, is this what we really want in our country? And it allows Congress to have information to cabin the authority of the president if we are. Because this is an American conversation because we're all paying for it as Americans.
Thank you all so much.
Okay.
Expedited. Is this going to be decided soon? So this will be decided. No,
Right. Good question. Even if it is, you know what?
Ladies and gentlemen, please welcome the 45th and the 47th President of the United States, Donald J. Trump.
From the lakes of Minnesota to the hills of Tennessee, across the plains of Texas, from sea to shining sea, from Detroit down to Houston and New York to LA, where there's pride in every American heart, and it's time we stand and say,
Wow, what a nice group. And I love Miami. I love to be with the people. Many of you are not from Miami, but that's okay too. And I'm thrilled to be back in magnificent Florida, Miami, Florida, with thousands of incredible business leaders and true American patriots. That's what you are. We're gathered today on the one-year anniversary of the single most consequential election victory, they say. This is them, this isn't me. I'm a very modest person, I would never say this. The single most consequential election victory in American history. It's possible. I mean, it's possible. We've done a lot. On November 5th, 2024, the American people reclaimed our government. We restored our sovereignty. We lost a little bit of sovereignty last night in New York, but we'll take care of it. Don't worry about it. We rescued our economy, regained our liberty, and together we saved our country. On that magnificent night, 365 days ago, you know, I was with a group of very important people, and they say, think of it, last week, just last week, 6 days ago, 7 days ago, they said, you were campaigning 1 year ago. I said, no, it felt like I've been in this position for so long. And it's right. At that point, 1 year ago, I was actually campaigning. We did the McDonald's shot. Remember the McDonald's shot? We did the garbage truck shot. And actually, the McDonald's one was the biggest hit in the history of Google. Can you believe that? Number one, the garbage truck did well, but not as well. I guess there's something about McDonald's, right? But it worked, and we won a tremendous election. We won all 7 swing states. We won the great state of Florida, by the way, by 1.4 million votes, which is unprecedented. Biggest victory ever in Florida, including an 11-point victory right here in a place called Miami-Dade County. We won the popular vote for the first time of any Republican in many decades. We won the Electoral College 312 to 226. And we won 86% of the counties in America. That's a big one. 2,700 to 525. I'd say that's called a landslide, right? We got more votes from African Americans than any Republican candidate in history. We also won a record share of votes from the incredible Hispanic American community. There might be a couple of us left. Biggest vote in history. And above all, we won a resounding mandate to make America great again, which is what we're doing. And every day since, I've been fighting to turn the promise made into the ultimate promise kept. We're going to do our job. We have a big job to do. We've done really well. I think it's the best 9 months, they say, of any president, and I really believe that if we can have a few more 9 months like this, you'd be very happy, you'd be very satisfied. But it's been pretty incredible, with trillions and trillions of dollars being poured back into our country by other countries and other places and people. 1 year ago, we were a dead country. Now we're a country that's considered the hottest country anywhere in the world. It's the hottest country. We are now in the hottest country anywhere in the world. And I'm pleased to report that today the United States has the strongest economy, the strongest borders, the strongest military, the strongest friendships, and the strongest spirit of any nation anywhere. We have the greatest economy right now. A lot of people don't see that. But if you look at what's happening with all the factories, AI, auto plants all over the country being built, that if you would have thought about that 2 or 3 years ago, you would have said it was the opposite. They were all leaving. Now they're all coming in. They're all coming back and then some. And I think that we can honestly say, and I think you're going to see it even more so over the next 12 months, that this is the golden age of America. This is the golden age. In the prior 4 years, crooked Joe Biden oversaw less than $1 trillion of new investment in the United States. So in 4 years, less than, think of it, less than 1 trillion. That was not doing too good. In 9 months, I've secured commitments of over $18 trillion, and we're going to have $21 trillion within the first year. So Sleepy Joe did, think of that. In 4 years, he did less than $1 trillion. We're going to have 21 trillion in 1 year. I would say it's slightly better. Slightly, just a little bit better. The stock market is set 40-time all-time record highs, and just recently, record high, record high, record high. All of them, all of the different exchanges. GDP growth in the second quarter was an amazing, almost 4%. And as you know, they said, oh, it'll be 2% or 1%. And it's been really helped a lot by the tariffs. It's been really helped incredibly, because this is really a transition period. We went from a horrible, failed country to a tremendous success. It's a transition, and yet we did almost 4%, triple and even quadruple almost every other country anywhere in the world. Think of that. In the third quarter, we're on track to achieve an estimated 4.2, maybe more, who knows. I think if you go a couple of years out, you're going to see numbers like you've never seen, because all of these places that are now under construction, they're being built, they're going to be open, and thousands of jobs, hundreds of thousands of jobs are coming in, even building them. But when they open, that's when you're really going to see the numbers. We're building some of the biggest buildings ever built anywhere in the world. The AI buildings, you know, they can cover, they show displays of them. They can cover the island of Manhattan. They're so big. They literally can cover the island of Manhattan. In 9 months, we've lifted over 600,000 Americans off of food stamps, which is a record. 1.9 million more American-born workers are employed today. Think of that. Almost 2 million American-born workers are employed today, more than when I took office. That's 9 months ago. Can you imagine that? And I tell Republicans, if you want to win elections, you got to talk about these facts, you know. It's really easy to win elections when you talk about the facts. And we have more people working now than at any time in the history of our country. Right now, we have more people working. These are things you have to talk about. It doesn't just happen. You got to tell them. It's wonderful to do them, but if people don't talk about them, then you can do not so well in elections. Wages for workers are rising at the fastest pace in over 60 years. Those are workers, and that's what we love. We love the workers. Since I took office, wages for the typical factory worker are up $1,300. Construction workers' pay is up $2,200, and miners are up nearly $5,000 this year alone. And that's good because it's not, you know, such an extra cost to the company. It really isn't. Somebody would say, oh, it's going to cost more. The fact is that they're doing such business like they've never done. You're going to start seeing numbers coming out very soon that are going to blow your mind. Under Biden, we had the worst inflation in modern history. We had inflation that was so bad, costing the typical family about $33,000 over a period of time. Their policies send food prices up 23. They come in, you know, when I first came in, I was in for 3 days, and one of the fake news members, they're all back there. That's a lot of press. Fake news. They said, egg prices are through the roof. I was there for 3 days, and this maniac, this lunatic person, happened to be a woman. Sir, what are you going to do about egg prices? And they'd gone up like 4 or 5 times. I said, well, you just told me it has a problem. And people weren't buying Easter eggs. You believe it? I said, we're buying Easter eggs for the White House, for the egg hunt, the famous egg hunt. But within a couple of months, we got them down. We have a great Department of Agriculture headed by Brooke Rollins, and we did a great job, and we got them down to the level they originally were a long time ago. And we have that in just about everything. And if we don't have it, we get them down. Their policies sent food prices soaring 23%, the Biden policies. And it wasn't him. It was the people surrounding him around the desk. He didn't know what the hell he was doing. Biden. How the hell did that happen? Well, I know how it happened. A rigged election. That's how it happened. Think of the damage done. Although I must tell you, but this is a much more powerful term. I mean, this is a much better term. In one way, it's bad to see how bad people... You're going to see the same thing in New York, by the way. You watch what happens in New York. Terrible. But you're going to see that same thing. And I hope it doesn't happen, but you're going to see it. Gas prices are surging to $5 a gallon, even higher, and mortgage rates skyrocketed by 152%. But under the Trump administration, all of that is changing. Prices are coming down very fast, and we're bringing them back to the beautiful part where you can have, and you can truly say, we're talking about the American dream again. You didn't used to hear that term. You heard it during my 4 years, and then it disappeared. Now you're hearing it again more than ever. Because we had the most successful economy in the history of our country during my first 4 years. We rebuilt the economy, cut the biggest tax cut in history. We had the biggest tax cut in history, the biggest regulation cut in history. That's why we had the great economy. And now the only difference is we're doing better this time. Actually, we're going to have a bigger, better, stronger economy than the first 4 years. And that was the most successful economy in history. Gasoline prices have plummeted to the lowest in 2 decades, and we're going to soon see $2 gasoline. Think of that, $2 a gallon. It was up to $4.50, $5. And you know, when you get gasoline and you get oil and gas down, it's so big, it's so massive, the importance of it, that everything else starts to follow. And that's what's happening. Grocery prices are way down, and Walmart just announced that the cost of their standard Thanksgiving meal, this is the greatest. They're greatest, they're wonderful. They come out every year with how much does a Thanksgiving meal cost compared to last year, right? And it always goes up, up, up. It's 40%, 30% more. Is 25% lower than 1 year ago. Isn't that great? That's a big deal, Rima. That's a big deal. I don't know if they care about that in Saudi Arabia, but here it means a lot. We got the princess here from Saudi Arabia. She's got a lot of cash. Serious cash, and she's a great person. So she doesn't care about the price of a turkey is down a little bit, you know, she doesn't have to worry about it. Since March, the price of eggs is down 85%. Energy prices are down, interest rates are down, despite the fact that we have a total nincompoop at the Federal Reserve. It was recommended by one of my real great people, who I'd never spoke to again. And the cost of the typical new mortgage is down by nearly $3,000 a year. Day by day, we're making America affordable again. It's going to be affordable again at a really record pace. And, you know, other people are going to take credit. All the mayors and all the governors, they're going to say what a great job. They didn't do a damn thing. Yet as we speak, the Democrats in Congress are trying to put all of this progress at risk and drag us back to the Biden policies of soaring prices, crushing energy costs, massive spending, open borders, let the world come into our country from prisons and from mental institutions, let them pour in, and rampant inflation. That's what Biden gave us, all of those things. With the reckless Democrat shutdown, virtually every Democrat in Congress has voted to hold the American people hostage in an effort to extort hundreds of billions of dollars in new spending. They're demanding free health care for illegal aliens that just came into our country from prisons and from mental institutions, and drug dealers and drug addicts, and they want to give them $1.5 trillion in giveaways that would turbocharge rapid inflation again, as they did the first time. You remember that just a couple of years ago, 4 disastrous years we just had. They were the worst years. Meanwhile, the radical left Democrats are causing millions of Americans who depend on food stamps to go without benefits. They're forcing federal workers to go without paychecks, and they're stranding thousands of travelers at the airports. And you understand it, and they understand it. All because they want to return to the failed Biden policies that created, and also Obama policies. I watched him the other day up talking, well, Donald Trump is a mean person. I'm not a mean person. I just want to have a country that's great again. Is that okay? I'm not a mean person. He's a mean person. He's a divider. He's a divider. Obama, Barack Hussein Obama. And by the way, ask him how he's doing in his museum library. He's got hundreds of millions of dollars of cost overruns. It's come to a dead halt. He built it in not a particularly good location. He's not into real estate, you know? He doesn't know about location. He doesn't know about location. But he built it in a location that's not going to be too good. But the thing has come to a dead halt. It's way over budget. It's sort of like Gavin Newsom in California. He's got a train that was supposed to go from San Francisco to Los Angeles, which is a stupid idea because an airplane is faster. I don't care how fast it goes. And they had plenty of airplanes. San Francisco, inside San Francisco to inside right there, L.A. And what they did is they said, oh, man, this has been going on for years. It's billions and billions of dollars over budget. So what they decided to do is cut it so that it doesn't go into San Francisco and into L.A. It cut way short of both. And then they cut it again and again and again. Pretty soon they're going to have like 2 miles of track. Billions and billions of dollars. Totally incompetent. The biggest cost overrun proportionately that I've ever seen. Many, many, many times more. And it's no longer the same. It was supposed to go into the city. Now it's way short, many miles short of the city. So they're going to drop you off and you can walk the rest of the way. That train is going to haunt him. You watch, because he doesn't have what it takes. I tell you that. Slimy guy. He's a slimy one. Maybe that should be his nickname. Slimy Newsom, right? But he doesn't have it. But you look at that train, it's going to cost him. Republicans have voted 14 times to fund the government. And it's time for Chuck Schumer, crying Chuck. Remember he started crying at the airplanes? They were the worst forced tears. I've known him all his life. He's never cried. But he broke down in tears. He was so devastated. He didn't know why he was crying, but he just thought it was good to do. His people told him this was a good time to cry. Crying Chuck. But it's time for Chuck Schumer and the radical Democrat Congress to stop playing games with the people's lives and to pass a clean funding bill that they've done 30 times before. And to reopen government immediately. Just reopen it. They don't like it to be reopened because we're setting records. They think actually, I don't think anything's going to hurt. We are so strong now that I'm not sure that anything's going to hurt. But it would be good to open it up. take care of the people with jobs that aren't going to get paid and aren't getting paid. And no matter what, we will not let them impose their inflation-causing extremism on the American people. We're not going to pay $1.5 billion for people that came into our country illegally, okay? If you don't mind. That's what they did last time. Remember the Inflation Reduction Act? The greatest scam, one of the greatest scams. I would say some of their environmental scams were even bigger, but one of the greatest scams ever, Inflation Reduction Act, and then they admitted it had nothing to do with inflation reduction, remember? But it did actually cause massive inflation. It actually caused massive inflation. But we don't use auto pens in the Trump administration to sign things. We don't believe in that. You know, I get these guys come in with these big, beautiful documents, gorgeous, beautiful, must cost a fortune if you check the price. But, you know, a general is being made or something, you know, some big post. And they say, sir, would you sign this, please? It's going to be a 4-star general, or it's going to be a big cabinet position, or it's going to be something with medical or whatever. I take my pen and I sign it. In his case, they walk it into a room and they give it to somebody who's no idea who Biden is. But Biden doesn't have any idea who he is either. And they have a machine sign it, the auto pen. And all of the pardons, he gave thousands of pardons to people. He had no idea about it. He didn't know about it. And therefore, all those pardons are void. You know, you have to have, it's a very complicated thing if you're going to use a machine. You have to do it properly. And he didn't have any idea what was happening. And this is what we had as a president. We don't want that. You have the opposite right now. I don't want to be braggadocious, but you have the exact, I know exactly what's happened. If you want to see what Congressional Democrats wish to do to America, just look at the result of yesterday's election in New York, where their party installed a communist as the mayor of the largest city in the nation. Remember, I've said we will never have a socialist elected to any post in our country. I used to say that, and I was right. We skipped socialist and we put in a communist instead. That didn't work out too well. But as I've warned for many years, our opponents are hell-bent on turning America into a communist Cuba or socialist Venezuela, and you see what happened to those places. For generations, Miami has been a haven for those fleeing communist tyranny in South Africa. I mean, if you take a look at what's going on in parts of South Africa, look at South Africa, what's going on. Look at South America, what's going on. You know, I'm not going to, we have a G20 meeting in South Africa. South Africa shouldn't even be in the Gs anymore, because what's happened there is bad. I'm not going. I told them I'm not going. I'm not going to represent our country there. It shouldn't be there. Take a look at what's happening in different parts of South America. Take a look at what's happening in different parts of the world. But now the Democrats are so extreme that Miami will soon be the refuge for those fleeing communism in New York City. They flee. They flee. Where do you live? New York City, but I'm trying to leave because I don't want to live in a communist regime. I hope it works out for New York. I love New York. I love New York. When I left New York for the White House, it was good, except we had, you know, the telltale signs of trouble because we had a guy named de Blasio. Do you ever hear of him as mayor? He goes down as probably the worst mayor in history. Then he went to Harvard to teach government. Do you believe it? They took de Blasio, and they took that mayor from Chicago, the woman, the one that gets her hair done very expensively, right? Beautiful hair. She got beautiful, luxuriant hair. And they took her, and she's teaching at Harvard. They're teaching government. And then you hear about Harvard. We're trying to work a settlement with Harvard right now for about, like, a lot of money. I won't tell you what, but you'll be reading about it pretty soon. Because what they've done to Jewish people and what they've done to others is pretty bad, I'll tell you. It's pretty bad. Going to cost them a lot of money. After last night's results, the decision facing all Americans could not be more clear. We have a choice between communism and common sense. Does that make sense to you? Common sense. It's common sense or communism. And, you know, you take a look back 1,000 years, it hasn't worked. If it worked, we'd be using it, I guess, but it hasn't worked. Our opponents are offering an economic nightmare. We're delivering an economic miracle. We have delivered in 9 months. This is the biggest investment of funds in a country in history by many times. That's good. They want higher spending for government and illegal aliens. We want bigger paychecks for American workers and American families, and that's what we're delivering. You see that? They stand for crime and chaos and corruption. We stand for law and order and justice. Also strong borders. Boy, do we have strong borders. They put America last. We put America first. We put America first. And as long as I'm in the White House, the United States is not going communist in any way, shape, or form. We'll stop it. We're going to stop it. Stop this nonsense. You know, I said they were voting last night. You can have a communist or a thug. A communist, and they took the communist, you know. It's pretty amazing. We could have done a little better in terms of candidates. From day one of my administration, I've been fighting every single day to turn around the catastrophe we inherited to make America the best place on the planet Earth to do business, and that's what it is. Right now, we're the #1 place. I'm getting plants approved in 2 weeks. It used to take 20 years before they got rejected. You'd have young people start off. Their whole business was getting a certain plant accepted. 22 years later, they're ready to retire, and they haven't gotten it. And then they go to a vote, and they get rejected after 22. They wasted a whole life looking for an acceptance. We do it in 2 weeks. We make sure it's good. We make sure it's great and proper, environmentally sound. Takes 2 weeks. My goal is to have the best tax rates, the lowest energy cost, the lowest regulatory burden, the most advanced technology, and the fairest trade deals anywhere in the world. You know, we're leading China. We're leading everybody by a lot in AI. And this was my idea, so I'm very proud of it. I said, build your own electric. People would come. We need more electric grid, sir. The electric grid's 200 years old. We need more electric grid. It's old. The electricity that the AI plants need alone is double the entire electricity that we have in the country right now. Can you believe it? So I had this idea. I said, we can't fix the old grid that much. We'll fix it up. We'll keep it going. A little Band-Aid here, a little Band-Aid there. It's old. And I said, here's what we're going to do. We're going to let these geniuses build their own electric generation. So they are building their own electric utility plants. They become a utility, if you think about it. They're building the utility and the electric right alongside. This is where they have their transformers and everything. They're building the most expensive electric plants you've ever seen, generating plants, some by nuclear, some by oil and gas, some by coal as a substitute. They're building them right next to their plant, and they're incredible. People say they've never seen anything like it because these minds are genius. To them, an electric plant is not complicated. To them, an electric plant is better than the people that produce electricity, although Florida Power and Light is doing a lot of plants for people. They're pretty advanced, I have to tell you. But they're building their own juice next to the plant. Isn't that sort of a cool idea? And you know, when I first proposed that, they came into my office with, you know, they have unlimited money, but they were trying to figure out how they can build it because they had no electric of any consequence. And I said, you're going to build your own plant. I'm going to get you your approvals in 2 weeks, 3 weeks, maybe a month if I'm slow. We have a great man, Lee Zeldin, in charge of the environment. He's incredible. And he's tough, too. He's very tough. But they have their approval in 2-3 weeks. You know, they're dealing with the best experts in the world. They know what they're doing. It's amazing when you see some of this stuff come in, designed by guys with 190 IQs, and then you have an inspector who's not quite as smart as that, inspecting it to see whether or not it's okay, and he has no idea what he's looking at. No idea. But I said, you're designing your own electric plant, and they didn't believe it. They come in 2 weeks later, they said, the biggest problem is electric. I said, you can design your own plant, and we're going to have your approvals within 2 to 4 weeks. And they said, he's really serious about it. They thought I was kidding. It was so good They couldn't believe it. They'd leave and they couldn't believe it. It took me 2 or 3 times to say it. Yeah, they're designing their own electric plants, and it's unbelievable. And then they're going to sell their excess electricity back into the grid. So we benefit in that way, too. In July, I proudly signed into law the largest tax cuts in American history. Now, that's the second time. I did it the first time, but these are even larger, the great, big, beautiful bill. And that includes no tax on tips, no tax on overtime, no tax on Social Security for our great seniors, no tax on Social Security. I wonder which is the most popular of the no tax on tips. You know, I was in Nevada, in my building in Las Vegas, and I had this beautiful young waitress come up to me. I never talk about beauty anymore because politically, if you mention somebody's beautiful, that's the end of your political career. So I don't mention that she was beautiful, but she was beautiful. And she came up and I said, "How you doing?" "Oh, sir, I'm not doing well. The government is horrible on tips." I said, "Really? How do they tax? They tax tips? They tax us and they go after us. I've never seen anything like it. It's made my life miserable. Sir, there should be no tax on tips." She said to me, "No tax on tips." I said, "Say it again." She said, "Sir, there should be no tax on tips." So we had a lot of the fake news waiting for me outside of the restaurant. So I went out, I said, "Ladies and gentlemen, I have an announcement to make. There will be no tax on tips." That's how it all started. And I won Nevada. I won Nevada. Because, you know, in Nevada, every job is basically, you know, you're a waitress or you're working in a hotel. No, that's how it started. So it was amazing. We won Nevada easily, which is usually not a stronghold for Republicans, but it's become a stronghold. So I want to thank the waitress. She did a great job. But when she said those words, "Sir, there should be no tax on tips," it's amazing. Somebody else would hire a consultant, pay them millions and millions of dollars. They'll come back and they'll say, "Sir, I think you should absolutely tax tips." And you'll lose the election. But we also have 100% expensing for all new factories, plants, and equipment, so your businesses can write it off all in 1 year, and that's a lot of jobs you're doing and producing. That was, to me, the biggest thing in the first bill. But this is even better because this goes for a 10-year period. Upon taking office, I signed an executive order requiring that every one new regulation, every time we issue a new regulation, think of this, 10 old regulations must be eliminated simultaneously. So if we give you one, you get rid of 10. And so far, for 9 months, we're exceeding that. And it's 30 to 1. For every new one we give, they're getting rid of 30 old, broken down regulations. And we've slashed nearly $1 trillion worth of regulatory burdens. We have regulations that are so old and nobody uses them, but they stymied a lot of production, a lot of jobs. And I did it the first time, and we had the largest regulation cuts in history, and now we're exceeding it this time. So it's big. That's a big, it's one of the reasons we did so well then, and I think it's one of the reasons we're doing so well now. Again, we have to talk about it, because if we don't talk about it, nobody else, the fake news is not going to talk about it. And we have streamlined permitting for the new energy and mining projects. What used to take decades now takes 28 days. And on day one, I signed an executive order to unleash American energy and officially terminate the Green New Scam. Has anyone ever heard of the Green New Scam? Remember the old thing, global warming, and then it would be too cool? And then they said global cool. They didn't know what the hell to say. So they came up with the greatest, climate change. No matter what, if it goes up, if it goes down, climate change. They're very, very smart people, but not smart for us. They're smart for them. But my policy was very simple. Drill, baby, drill. We're drilling like crazy right now. And to curb inflation, we've slashed the size of government for the first time in years, and we're waging total war on waste, fraud, and abuse like we've never done before. Since January, 100,000 bureaucrats have left the federal payroll. Government spending is down 2.5% this quarter compared to 1 year ago. Think of that. And in stark contrast to last administration, 100% of all new jobs created in America under my administration have been created in the private sector. 100% of the jobs have come from the private sector. Otherwise, you don't have a country. I mean, I love government workers, but if you have all government workers, you don't have a country, do you? At the same time, my tariffs are bringing in hundreds of billions of dollars and are helping slash the deficit this year by more than 50%. Did you see the numbers? We're going to be down 50%, anywhere from 25 to 50, but closer to 50%. Who would think that one? Those are big numbers. Now, take that out 2 or 3 years. To embrace a vital industry here in Miami, I've also signed historic executive orders to end the federal government's war on crypto. Crypto was under siege. It's not under siege anymore because it's a big industry. It's a big industry, and I have a lot of people that are great people, great business people. They're in other businesses, but they're in crypto too. And it takes a lot of the pressure off the dollar. It does a lot of good things, but we're into it. Biden was vicious on crypto. They were going after these crypto guys. It was terrible. They were under indictment, but I got indicted too. I made a phone call. Congratulations on your victory. He made a phone call. Let's indict him. These people are the worst. Then they say, he's gone after Comey. They indicted me. They impeached me. They did everything. It's unbelievable. Who the hell else could have taken that? Do you guys know anybody else that could have taken it? I don't think so. A lot of people say, you're the only one could have taken that. I don't know if that's true, but there aren't too many. We're making the United States the Bitcoin superpower, the crypto capital of the world, and the undisputed leader in artificial intelligence. We're leading China by a lot. And don't forget, if we don't do the crypto properly, China wants to do it. They're starting it, but they want to do it. Other countries want to do it. If we don't do it, it's a big industry. We're honored to be joined today by a man who has been a true champion for many of these bold policies. He really has. He's been a great guy. He was a little late in his endorsement of me, I'll be honest with you. He endorsed me. You know, these guys that endorsed me after I won, I don't know. Sir, I'd like to endorse you. No, I won the election. Nah, he's a good man, actually. I've known him a long time. He's helped turn the area into one of the hottest markets in the country and one of the greatest cities in the world. Miami Mayor Francis Suarez. Please, Francis, come up, please.
You're never gonna let me forget that one, huh? Thank you, my brother. Thank you, Mr. President. Just a little shorter than you were. Oh, it's truly a great honor to be here with you this afternoon and to have you here once again in the great city of Miami. Your leadership and your vision have shaped not only our nation, but also the future of our city. Miami's success today is rooted in the values that are deeply American: opportunity, freedom, safety, and innovation. These are values that you have championed with conviction, and they are the same values that have made Miami a symbol of what's possible. When people believe in the promise of America, Mr. President, I want to personally thank you for your continued support of our vision for this city. It was an honor to stand beside you in the Oval Office when you announced the next year's G20 right here in the city of Miami. Thank you for choosing our city to host what is perhaps the most important and consequential gathering of leaders from around the world. Miami has come a long way, and we will rise to the occasion, Mr. President. On behalf of the people of Miami, it is my privilege and honor here on behalf of my wife, the America Business Forum, Nacho, Sergio, and everyone to give you like real estate, right?
I do.
Yeah. This is a key that opens some really nice presidential library real estate.
That's beautiful. Thank you. Thank you very much, Francis. I appreciate it. And you know, he's really a special guy. I'm going to take this, I'm going to put it in the White House, and then I'm going to move it to Doral in about 3.5 years. We put it right in Doral, right? In the lobby of Doral. A lot of people from Doral. Well, thank you. That's a great honor. I also want to thank a man who's been unbelievable in terms of Israel and so many other things. You know, he was a great real estate developer, but he had a great personality. And you need a personality for this. And I said, he's just as good as there is, and he's done so well. And you look at what's happened with Israel. We have peace in the Middle East. Can you believe it? Peace in the Middle East. And he's special envoy Steve Witkoff. Steve, where are you, Steve? Wherever you may be. Where are you? Steve, thank you. What a job you've done. Thank you very much. What a job he's done. That guy's got that personality. Now, I wanted a deal maker, but, you know, a lot of deal makers don't have good personalities. You end up in a war. They make the deal, but you end up in a war. This guy, everybody loved him for years. I've known it. And he was the right guy for the job. Peace in the Middle East, 3,000 years. They've never had peace in the Middle East. We're going to have it, too. We're doing well. Just keeps going along. And we just had a meeting. It's even more and more so. And so many people in this room are very much into Israel and the Middle East. And it's been amazing what we've been able to do. And you've done such a big part of it, along with a very special young genius named Jared Kushner, who helped you so much. Stand up, Jared. And he's the father of the Abraham Accords, right? He's the father of the Abraham Accords. And by the way, my granddaughter, Arabella, would you stand up, Arabella? She looks so great. I said, how are your marks in school, Arabella? Grandpa, I have all A's and A+, you know that. Like it was a stupid question I asked her, right? We're proud of you, Arabella. Jared, thank you. What a great job. But we have a lot of people joining now the Abraham Accords. And hopefully we're going to get Saudi Arabia very soon. But I'm not saying that. I'm not lobbying. No, but we have a lot of people. We have a lot of people that are coming aboard. You know, the key was when we took out the nuclear capability of Iran, all of a sudden everybody said, wow, that was nice. They've been wanting to do that for 20 years. Saudi Arabia's ambassador to the United States, Princess Rima, thank you very much. Please stand up. Thank you. Thank you. Thank you very much. Say hello to everybody. Okay? Say hello to a great group of people in Saudi Arabia. Thank you. Stephen Miner, Mayor of Miami Beach. Stephen Miner. Where is Stephen? Thank you, Stephen. Thank you. Good job you're doing. Excellent. Thank you, Stephen. The Mayor of Coral Gables, Vince Lago. Vince Lago. Thank you. Thank you. Great job, Vince. The Mayor of Doral. I love Doral. And I like this woman a lot. Christy Fraga. Christy. Where's Christy? Thank you, Christy. I like Doral. We also have Commissioners Damian Pardo, Laura, Dominguez, Ralph Rosado, Miami-Dade Supervisor of Elections, Alina Garcia, the President of FIFA, Gianni Infantino. FIFA, where's Johnny? Whoa, Johnny, my boy. I didn't know he was going to be here. He's big stuff. And the world, look, you know, Johnny and I worked the deal originally, and it looked like I wasn't going to be president because it was in this term, right? So when they rigged the election, I said, oh, man, I have to run again because I want to be president when they have the World Cup, right? And look what happens, Johnny. I'm president when we have the World Cup. It wasn't supposed to be that way. But I can only tell you that the tickets are selling at numbers and record like they've never sold ever before. I heard you just told me that they're doing record business, right? We had the World Cup coming. Think of it. We have the World Cup coming. We have 250 coming, and we have the Olympics. 250 is 250 years of age. And we have UFC at the White House, by the way, on June 14th. That's going to be at the White House. That's going to be a tough ticket. That's UFC, but we have, think of it, Johnny is there with FIFA, and we have the Olympics. We have it all coming. It's all this thing. I'm glad I'm sort of happy the way things worked out, you know? It's turned out to be as good as it could be. I think we've made more progress than we ever could have made in the second term. I think this is really more progress being made. We also have Formula One CEO Stefano Domenicali, and where's Stefano? Very good. That's big stuff. We have a lot of big people here today. We also have a gentleman who called my election successfully. He said, and Donald Trump will be the next president of the United States. Got a great voice. Brett Baer. Where's Brett Baer? Brett Baer. Where is he? And his son is with him, Paul. Paul's a very good golfer, so is Brett. Thank you, Brett. He's doing an interview with me right after the... Oh, is that Paul? Stand up, Paul. Paul, did we take your father easily in golf? Tell me, huh? That was easy, right? Get ready. We'll do it again. Thank you very much, Paul. You look great. Also, I want to thank your two great senators, Ashley Moody and Rick Scott. And, you know, I just left them. Believe it or not, I had a meeting with all the senators this morning. I gave them my vision because, frankly, it's always nice to have good vision. And they are two terrific senators, and they're in Washington working hard, and they were going to come. And I said, do me a favor, stay back and work on the things you're working on. They're working on really things. And Ashley is in the election. Rick just won his election. They're two great senators that you have right here in Florida. So that's really good. And they're working to make America great again. So I said, stay back in Washington. Together with many of the people here today, we've achieved more in 9 months than most administrations achieve in 8 years. It's true. We've really done a lot. We inherited the worst border in history, and within a matter of weeks, we turned it into the strongest border anywhere in the world, and they have some pretty strong borders, but we have literally no people coming through. They do come in. They come in legally. You know, we want people to come in. We want to make it real easy for them, actually, but they come in legally. So you have to know that. We just don't want criminals coming in. We don't want people from prisons. We don't want prisons dumped into our country like Venezuela did. They emptied their prisons into our country. We don't want that, right? For months in a row, 0 illegal aliens have been admitted into the United States. 0. They actually announced it. This is an official 0. Remember when Biden said, I have no control over the border? Millions of people pouring through, not people that you could look at them, not that we discriminate. You could look at them and say, these are not going to be perfect for our country. They were rough people that they let in. They had 11,888 murderers, 50% of which murdered more than one people. We don't want them. We're getting a lot of them out. Hopefully we're going to soon have all of them the hell out of here. Either out of here or we have to put them in jail because they're so dangerous. Some are so dangerous we don't want to bring them out. We'll just make sure they never come back in. But this is what they were putting in our country, and it's a disgrace. On day one, I signed an executive order to designate the drug cartels as foreign terrorist organizations. We had a big, strong, positive number come out just recently. The drugs coming into our country are way down. I'll tell you where they're really way down is drugs coming in through water. People are saying, no thanks. I don't think I want to ride in that boat today, please. We want you to take these drugs into the United States. You know what? I think I'll take a pass, sir. The drugs coming in by border are not much. Every boat that we hit kills, think of this, if it gets through, kills 25,000 Americans plus, but 25,000 Americans. Every time we hit a boat, we save 25,000 lives. Got to look at it that way. And we're arresting and removing thousands and thousands of dangerous gang members, MS-13, Tren de Aragua, all these gang members are being thrown the hell out of our country. And if you look at Washington, D.C., it's now a safe community. We're in Memphis now, and within 2 weeks, all of a sudden, it's like a safe community. It's really made unbelievable progress. And we're blowing up cartel terrorists. And we're blowing them up linked to the Maduro regime in Venezuela and others. Look, it's not just Venezuela. But a lot of things are coming in. Look, Venezuela emptied their prisons into our country. Nobody wants that. They emptied their prisons into our country. We're liberating our cities from the scourge of violent crime, making our country safe and beautiful again. We're starting in our capital, Washington, D.C., which right now you can walk through the middle of Washington. You have no problem. 6 months ago, that wasn't the case. 1 year ago was a disaster. But law enforcement, our military has done an incredible job, actually. It's a safe, very, very safe city again. And it's been beautified. We're putting new medians in. We're covering the roads with nice, clean, beautiful asphalt. We're redoing the grass in the parks. It's really becoming beautiful again, and it's safe. We don't get calls that, think of it, call to the parents, your son, sir, has been killed. He came to see the Lincoln Memorial and he's dead. No, that's not happening anymore. We run it tough. We run it very tough. Sometimes you have to be a little tough to get rid of. These are thugs. These are bad people. We're bringing them the hell out of our country where they came from. We renamed the Department of Defense to the Department of War. And, well, if you think about it, after the Second World War, they changed it to defense, right? So we won the First World War. We won the Second World War. We won everything in between and everything before, never lost a war. We still don't lose wars. Sometimes we don't fight to win. You know, we'll stay around the country for 15 years, just bomb the hell out of everybody, make everybody miserable. Nobody knows why we're there, you know, the wars that never end. But we made it clear that the days of political correctness in our military, they're over. We don't want to get into wars. I rebuilt the military. We have the strongest military by far in the world. We make the best equipment, the best missiles, the best rockets, the best everything. We redid our nuclear. We're the #1 nuclear power, which I hate to admit because it's so horrible. It's such a horrible situation if it ever has to be used. Russia's second. China's a distant third, but they'll catch us within 4 or 5 years. They want to catch us, and they'll be able to catch us. And we're maybe working on a plan to denuclearize the three of us, so we'll see if that works. But we have the strongest military anywhere in the world by far. We're investing $1 trillion in the United States Armed Forces this year. It's the biggest amount we've ever invested, and the spirit of service members is soaring like never before. We used to have recruiting shortages a year ago. You remember, you couldn't get people to join our military all around the world. You couldn't get them to rejoin. You just couldn't, no matter what you do. That we were way short. Now you can't get into our military. The waiting list, you have waiting lists to get into our military because we have spirit in our country. And all around the world, America is making peace, and we're really making peace through strength because they know they're not going to mess around with us. Nobody's going to mess around with us. You saw what happened. We made a deal with China last week, and we made a deal with Japan last week. We made a deal with Malaysia. They helped us so much. All great economic deals, all great. Great for everybody. In 8 months, I ended 8 wars, including Kosovo and Serbia, the Congo and Rwanda. That was going on for a long time. Pakistan and India. You know, I was in the midst of a trade deal with both of them. And then I read on the front page of a certain newspaper, I said, I don't want to mention the newspaper because it's usually fake news, but I heard they're going to war. 8 planes, 7 planes were shot down. An 8th was really badly wounded, but 8 planes were shot down essentially. And I said, this is war. And they were going at it. And they're 2 nuclear nations. I said, I'm not going to make any trade deals with you guys unless you agree to peace. No way, this has nothing to do. I said, it has everything to do. Your nuclear powers. I'm not trading with you. We're not making any deals with you if you're at war with each other. A day later, I get a call. We've made peace. They stopped. I said, thank you, let's trade. Isn't that great? Tariffs did that. You know what? Tariffs. Without tariffs, that would have never happened. Israel and Iran, Egypt and Ethiopia, Armenia and Azerbaijan, and Cambodia and Thailand. All of them were in war, starting war. Some of the wars were 32 years old. One was 38 years old. Amazing. They tried to, President Putin, I spoke to him 2 weeks ago, and he said, on the one, He said, we've been trying to settle that war for 10 years. We weren't able to do it. You got to settle. I got some of these things settled in an hour. No help from the United Nations at all. The only thing I got from them was a blank teleprompter. Remember I went up there, Princess? Ladies and gentlemen, on behalf of the United States of America, President Donald J. Trump, I'm looking at the teleprompters, and I have all my friends, including your family, sitting out there, 158 leaders, some in beautiful silk white robes, others in bad shirts, bad ties, and some in beautiful shirts and ties. But they're all the leaders, 158 leaders. And they're saying, President, and I'm walking up to the President Donald J. Trump, and I'm looking at the teleprompter, stone cold blank. They did it on purpose. And I think I gave my best speech. That's what I was told. But it still wasn't a great feeling. I'm walking up very slowly, you know, I'm 20 feet, I'm trying to walk slowly because I see it's not working, they're dead. They did it on purpose, but it worked out okay. Not great people. Most important of all, for 4 weeks ago, and this is very important, we brokered the historic peace deal that ended the war in Gaza, and it's a serious end, too. You know, I read a lot of people, oh, it's very tenuous. Jared and Steve, I don't think it's tenuous, do you? I hope it isn't, because otherwise I'll have to cross it off. I'll have to say I only ended 7. But that was a tough one, right? That was a tough one. But there's nothing tenuous about it. It's a serious end. Gaza has been a disaster for so many years, and I think it's an end. I think you're going to see some tremendous things happening. We just had a meeting just before I got up, and some great things are happening. And with Israel and peace in the Middle East, it's amazing, actually, what they've done. And what you two guys have done have been incredible. On day 1 of my administration, I signed an executive order to slash federal funding for any school that pushes critical race theory or transgender insanity on our youth. And we completely banned the chemical and surgical mutilation of our children. Think of that. Can you imagine somebody 15 years ago saying we stopped the surgical mutilation of our children? We stopped the chemical mutilation of our children. Can you imagine that? They would have said, this guy's crazy. And now you're saying, thank you very much, because you know it's true. How about this one? We got men out of women's sports. It's over. It's over. Men out of women's sports. They had a race the other day, long distance, I don't know what the hell, a race, one of these all-day races. They had the top women, the top men. The man won by 5 hours and 18 seconds, okay? What the hell? How about the weightlifting? 218 pounds by women. That's a lot to lift over your head, Rima. I don't know if you might be able to do it. 218 pounds or whatever was the record. A man beat the record by 100 pounds. It stood for like 17 years or something. A man beat the record by 100 pounds. He was a failed male weightlifter, but as a female, he did very well. That's a record that won't. This is a thing that stood. They put a quarter of an ounce and a quarter of an ounce on each end. 18 years the record stood. Then a guy comes along, ping, ping. This is a crazy, these people are crazy. And Mandami, whatever the hell his name is in New York. No. He thinks it's wonderful to have men playing in women's sports. The swimming's good too, you know? You know the story? Records are being beaten by numbers that nobody's ever seen, nobody ever thought possible. But a lot of those records are being changed back to where they should be, and I made it the official policy of the United States government that there are only 2 genders, male and female. And we're restoring the name of a great president, William McKinley, to Mount McKinley, the beautiful Alaska mountain I renamed. Think of that. They took the name of McKinley. He was a great president. He was assassinated. He was a great president for tariffs. He was the tariff king, and he made our country very rich. And then Teddy Roosevelt spent the money on the Panama Canal and many other things. And everyone thinks Teddy was a great president. He was. But the one who built all that money was McKinley. So we renamed the mountain back to Mount McKinley. Is that okay? I think so. You know, I'll tell you what, who's happy about that is the great state of Ohio. He was governor of Ohio and became president, did a great job, made the country very rich. He was killed. Mount McKinley was named, and then the name was taken off, and we put it back on. And I renamed the Gulf of Mexico to the Gulf of America. That was an easy one. That was an easy one, Johnny. That was easy. You know, I looked, we have 92% of the shore. I used to say when I was a child, I'd say, how come it's called the Gulf of Mexico? It's mostly America. You know, all the way, it wraps around Florida, all the way up. It's 92% of the shoreline. I said, I think to me it's the Gulf of America. Little did I know I'd have the chance to do it. I did it very quickly. For years, our country was run by radical scoundrels and far-left bureaucrats who created one catastrophe after another, wrecking our economy, erasing our borders, and surrendering America's power and standing all over the world. But after just 1 year since that glorious election, I'm thrilled to say that America is back. America is back. Bigger, better, stronger than ever. And in conclusion, jobs are returning, businesses are booming, and America is respected again, perhaps like never before. Our country is respected again like never. They were laughing at our country. We had a guy who couldn't walk up a flight of stairs. He kept falling. It's very embarrassing. You know, at Air Force One, I go, sir, would you like the short stairs or the long? I say, give me the long every single time, please. The short ones, they call them the children's stairs. I don't want the children's stairs. Doesn't look so good coming out of the children's stairs. Now, if the weather's bad, it's okay, right? If you don't mind. But the communists, Marxists, socialists, and globalists had their chance, and they delivered nothing but disaster. And now let's see how a communist does in New York. We're going to see how that works out. And we'll help them. We'll help them. We want New York to be successful. We'll help them a little bit, maybe. For all of these failed and discredited, really discredited, if you think, ideologies of the past, their day is over, their grip is broken, and their time is absolutely done. The golden age of America has begun, and we are just getting started. It's a golden age like you've never seen before. From the steel mills of Pittsburgh to the oil wells of Houston, from the car plants of Detroit, and those car plants are pouring into our country, to the coal mines of West Virginia, those coal mines are opening up one after another. Clean, beautiful coal. You're not allowed to use the word coal unless you say, in my administration, unless you use two words before it. Clean and beautiful. Biden would say, unless you use two words before it, here you go, clean. He said, what happened to the other word? Remember those things? He'd say three words and mean two. But the West Virginia mines are doing unbelievable now. Wyoming is doing unbelievable. It's clean, beautiful coal. And from the bright lights of Las Vegas to right here in beautiful Miami, America is proud. America is confident. America is growing and successful. America is a great nation again. We're a great nation again. It's happened faster than I thought. I'll be honest again. We're respected by everybody. We are really, you see the way I get treated. I get treated that way. I guess a little has to do with me, but a lot has to do with the fact that I'm representing this country. America is respected again. America is a great nation again. The American dream is surging back to life, and we will never let the American dream die. Together we will make our country stronger, richer, safer, freer, and greater than ever before. And every day my administration will fight, 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 and America will win, win, win. I want to thank you, Miami. I want to thank you, Mr. Mayor. I want to thank everybody for being here. God bless you, and God bless America. Thank you very much. Thank you, everybody.
you. Thank you.